Sorry, you had a program in the city civil court, so we are late.
May I?
We will take from that side. Yes. Anyways.
My lord, kindly mentioning because wrongly the original certified copy has been numbered. Without the leave of the court, the department will not take this.
It will appear as to be mentioned. Will pass direction or what?
Paginated one.
My lord, just
Leave will be sufficient. What has been numbered?
Paginated, yes, paginated the certified copy.
the pagination has continuously been paginated, the original also, the original certified copy.
So what do you want to do now?
Just leave so that we can file with the paginated.
You cannot paginate the original. You have to furnish a fresh copy. It cannot touch the certified copy. It loses its sanctity.
We suffer limitation if we will file another copy.
No. We cannot grant that list. Sorry. Because that's contempt. That's contempt. Cannot sanction that. Sorry, no.
My lord, it has happened in advertisement.
It's inadvertent contempt then. No. Yes.
My lord, one memorandum of appeal along with 2 connected applications, my lord.
For what?
My lord, for inclusion, it has been filed
Under what heading?
under heading application, my lord. Lordship, leave to file review without certified copy.
Yes.
Grateful, my lord.
Yes.
May I have my lord's kind leave? My lord, with the leave of my lord Justice Uday Kumar, this is the my lord, the order dated 18th April, my lord, passed by your lordship, Honorable Justice Shobhoshachi Bhattacharya.
What do you want now, Mr. Sinara?
My lord, this is arising out of a writ petition, my lord. This is a criminal contempt, my lord, because the order.
Contempt application?
Yes.
We just have to refer to the division bench. I just have to refer to the division bench.
My lord, this is the single bench contempt.
Criminal contempt cannot be taken up by a single judge. Anyway, let it come in the list, in the single judge's list. Yes. My list.
With the leave of Justice Kumar, may we be permitted to mention a matter on the original side? Well, this is the
original side.
The office I have requested. That's why, my lord.
Yes, what do you want?
Item number 7 to 9 of your lordship's tomorrow's list, my lord.
Yes.
I'm in some difficulty. I'm not in Calcutta, hence I'm mentioning it in advance.
If you take up the matter, ask somebody to
Yes,
be there.
I'm just mentioning so that, my lord, it seems.
No, neither. Yes. Inform your other side, Mr.
That's why I brought him.
But that's why his face was poker face. I thought. Yes.
Lordship, I am mentioning one application
Yes,
for
application.
Guardians and Wards Act. Grateful, Lordship.
Guardians and some others. Custody first.
The appeal bearing FA number 273 of 2016, accordingly dismissed on contest, thereby affirming the impugned judgment and decree dated December 22nd, 2014, passed by Learned Civil Judge Senior Division, 5th Court at Alipur, South Chobis Pargana, in title suit number 90 of 2009. And 4 of 2022 stands consequently dismissed as well. There shall be no order as to the cost. Formal decree be drawn up.
Grateful. So you could have dismiss. Yes, my lord. Grateful. Yes. Accordingly, can 3 and can 4 of 2025 are dismissed on contest. FA 55 of 2023 is also dismissed on contest, thereby affirming the judgment and decree dated January 19th. We have given the details. The grant, thereby granting probate of the last will and testament of late Badal Chandran Noskar, dated such and such in favor of the plaintiff's respondent number 1. Can 2 stands consequentially disposed of, no orders to cost. Appeal is dismissed. Accordingly, sorry, Mr. De. Accordingly, WPLT 173 of 2024 is allowed on contest, thereby setting aside the impugned judgment dated such and reviving the order dated March 27, 2014 passed by the Tika Tribunal, whereby the substitution application filed by the respondent numbers 6 to 8 was dismissed. It is hereby held that on the demise of Arun Chandra Khanna, one of the partners of Messrs. Khanna and Sons, the right to sue does not survive on the heirs of late Arun Chandra Khanna. And since Tarun Chandra Khanna, the sole surviving partner, is arrayed as an opposite party and has taken a specific stand that the partnership firm was not a ticket tenant, as well as since the partnership firm itself has dissolved on the demise of Arun Chandra Khanna, since the number of partners has come down to 1, miscellaneous case number 19 of 2013 has abated. No address to cause adversary.
Lordship, may I humbly pray for expeditious disposal of the application before the tribunal?
Not double jeopardy for that.
I'm grateful.
Yes.
Lord, for item number 4, my lord, I beg to appear on behalf of the appellant. There was a direction to service wide order dated 11th.
Yes, yes.
But my lord, unfortunately, my lord, I have served it on 12th, my lord, on through India Post. There is some, my lord, I will be candid before your lordship, my lord. There is some issue with the India Post, my lord. It is.
Yes, yes, we know that.
My lord, may I?
When did you send?
I have. It is sent to Islampur, my lord. On
When?
12th of 12th.
12th of August.
12th of August, my lord.
No, 12th of August cannot be.
12th, my lord. 12th of August, my lord, I have posted.
18th August. Oh, 18th August you had asked for time. We
Yes,
had
my lord.
directed you when? 11th of August.
11th of August.
So very next day.
Very next day, my lord. My lord, I am carrying the track report even today, my lord. It is showing that it is struck in Jalpaiguri, my lord. There is some issue with it, my belief. May I have your lordship's leave
You
to
file that, we'll send it to mediation. No use holding it up.
in that case, my lord, I will file an affidavit in service through this.
Do that. Do that today. We'll
May I have your lordship's leave to serve it through WhatsApp because it was a communication, my lord. If
Learned counsel for the appellant submits that due to certain glitches in the official website of the postal department, the track report is not indicating proper service as yet. Full stop. Learned counsel for the appellant seeks leave to serve notice through WhatsApp or other electronic media. Full stop. Next para. Such permission is granted. Full stop. Let such service be effected by tomorrow. Full stop. An affidavit of a comprehensive affidavit of service regarding both modes of service shall be filed on August 25, 2025, when the matter shall next be listed under the same heading.
grateful
Do
to
it
you,
by today. Try to do it.
my lord, I
That's
will do
WhatsApp
it today,
thing,
my lord.
and file a composite affidavit of service, and Monday will take up and pass
My
it.
lord, grateful.
Thank
I have notice upon the learned advocate.
you. Yes, Mr. It has been served.
Sir, yes.
Right. The receipt indicating service of notice on the learned advocate for the respondent filed today be kept on record. Full stop. Despite service, none appears for the respondent. Mr. Khushwal is sending it for mediation. Let us have a chance. Since the matter arises out of a matrimonial dispute, we deem it fit to send the matter for exploring the avenue of mediation. Full stop. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of mediation. The receipt filed today be kept on record. Thank you. পরের ফাইলটা রেডি করে রাখো। None appears for the parties at the time of call. Full stop. Since the matter arises out of a matrimonial suit,
Malat, I am there.
we are sending it for mediation. This is affidavit of service, good service.
Good, sir.
Affidavit of service, affidavit of service filed to be kept on record. Despite service, none appears for the respondent. Full stop. Since the matter arises out of a matrimonial dispute, let the we are of the opinion that the same can be resolved by mediation. Full stop. Accordingly, the file be sent to the Calcutta High Court Mediation Committee for the purpose of resolution through mediation. The affidavit of service filed to be kept on record. Thank you.
But any time limit?
Time limit, statutory time limit is there. No difficulty.
But I beg to appear on behalf of the petitioner, my lord. Will I beg to represent the state lordship?
12 can? কত টাকা 7 টাকা হ্যাঁ 7 Mr. Shenmugam, you are
I'm
right.
But the order under challenge before Lordship, my lord, the order passed by the learned tribunal. Last some pages, my lord.
Mr. Hussain, give us a brief background. What is the fact?
Lordship, my lord, one title suit was filed in the year 1977,
Filed
challenging the order of vesting
by you.
by me. And thereafter, my lord, order was in favor of the petitioner. Decree was passed directing the concerned authority to correct the record of rights in terms of the civil court judgment order decree. That was communicated, that has not been complied with. So petitioner moved this Honorable High Court on 2 occasions. And the Honorable High Court Justice Manoj Mukherjee was the, as his lordship then was pleased to direct the concerned authority to consider the application and correct the record of rights in terms of the judgment and decree passed in the civil court.
That decree was never challenged.
No, till date.
Degree was to correct the records, all right?
Yes.
You applied for that. That is your grievance. That was not done.
That was my grievance. And I filed an application before this Honorable Tribunal also, my lord. And it was specifically stated in my petition that the inaction on the part of the respondent authority in not correcting the record of right in terms of the judgment and decree passed by the competent civil court.
Right.
And not only that, my lord, also the inaction on the part of the respondent authority.
He could have implemented the decree by executing it. Anyway, since you have already approached, so much time has elapsed. So what was the ground for dismissal of that by the tribunal?
Very peculiar ground has been taken by the land tribunal. But kindly see, I beg to draw your attention, page 1 of the impugned judgment, impugned order.
Yes.
This OA has heard on 24th February 2025 in presence of such and such. Kindly see the next 3 lines. The instant original application was heard in full on 24th January 2025. Total non-application mind. If that was heard on 24th January, so how it can be heard on 24th February 2025?
That is a mistake.
Mistake, no, that is mistake.
What is the ground? Let us see.
And kindly see the observation. Accordingly, the last 2 lines, the original application was filed by the applicant for inaction on the part of the BL and LRO memory such and such in the matter of compliance of the order of the civil code as well as the Honorable High Courts, Calcutta, and also the order of the ADM and DLRO on 13 October 2027. That was the initial observation of the learned tribunal. And now kindly see the operative last portion, page 4 of that order.
So since you have skipped a forum and gone to the civil court,
Yes.
let us see the decree once. Decree. Your main relief was changing the record of right, or declaration was short.
That
No, your main relief in the suit was for
for decree, for correction of record of right.
Page 56.
And order was also page
56.
Page 56 to 63 is the judgment passed by the
It was an
learned civil.
ex parte degree.
No, state was there.
State was there. Never took the point.
Vesting issue, not correction of record.
Whatever, you cannot say, the tribunal or the PLRO cannot say that the civil court did not have jurisdiction. Yes. It's not a nullity. It's a jurisdictional error which could be challenged. Since the decree of civil court is that you have to comply.
No, my lordship, let my learned friend complete.
Anything else you want to add, Mr. Hussain?
Lordship.
Anything else you want to add?
And page 63 is the operative portion of the decree, my lord.
Same.
Page 63.
Same.
Lordship, that is my humble submission, lordship.
Maybe there is some jurisdiction.
Whatever maybe, but
it's a
because
civil
they
court.
cannot, yes.
And it was a contested degree.
Yes. And I've got one of the judgment of the Honorable High Court. I must not produce before lordship.
No, why not? About what is the
Because the same point was held by the Honorable High Court.
You
That when a judgment was there, decree was passed.
You can cite it, Mr. Hussain, if you're happy to cite.
No,
Because otherwise it will be maybe a one-line judgment by us. This will add another line.
yes.
Subject to hearing, Mr. Galiba.
Grateful to lordship.
Give us half a minute, Mr. Galib, we'll just go through this.
Lordship. Citation ta dada.
আমার কপি একটু পরে দেবো WPLRT CHN
11-3.
WPLRT 2011 Volume 3 CHN
Proposition.
But there it was somewhat different. There it was a declaration of title sought first. That is what we asked you. That would be maintainable. Otherwise, if we were the civil court, we would not have allowed it, decreed it. Because only prayer, if the only prayer is decree for correction of record of right, it is barred by law. But here, the learned bench considered that the civil court had passed a decree for declaration and it was a consequential relief. But it is also held in para 3, you are right. Declaration, no, but para 3 says, since the writ petitioner set up a case for declaration of his title by a decree of civil court, finding of learned tribunal is contrary to the provision. So that was the ground given. And records of right do not vest title and all these things. It was different consideration. But independently also, we think you are right, because since there's a civil court's decree, it would be contempt not to comply. Anything you want?
No.
Yes.
My lord, my first respectful submission with regard to my lord civil court's decree. With deepest of respect, my lord, the civil court's decree, my lord, was on the issue of vesting. So when the my lord, when the question is on the issue of vesting, my lord, whether that, my lord, is a nullity, because the very jurisdictional issue was in question, and if a, my lord, decree is without jurisdiction, it's an honest. Now, second issue, my lord, so my learned friend has already related. So there are two issues involved in this particular matter in my respectful understanding, humble understanding. First is that there is a decree. What was a decree for my lordship? Kindly, my lord, may I respectfully invite your lordship? 56 once, kindly cease. May I take some time, my lord, because this is lordship. Kindly see the decree. The suit was by the predecessor in interest of the present petitioner, Abdul Wahid Mondal. 56. What was the suit for? Plaintiff's case in brief is that the A scheduled lands of plaintiff, agricultural lands owned and possessed by him, its total area does not exceed ceiling limit as prescribed by the provision of West Bengal Estate Acquisition Act. This was the issue. Now, what was the fine? Kindly see the issues framed, my lord, at page 58. State was a defendant. What were the issues, my lord? Relevant issues are 5. Kindly, did the plaintiff submit B form return to Big Rayat case? Finding with regard to 5 is at page 59. Plaintiff has denied submission of B form in the alleged findings. Lordship, 15 is a page 59 is a finding of issue number 5.
Right.
Finding returns on this. Plaintiff number so denies submission of B form in the alleged BR case by him in respect of his lands. DW1 employee in the settlement office.
Did not even raise the jurisdiction point, Mr.
Lordship. Now, my lord, 6 to 11, say 6 to kindly see issues, was the plaintiff at all liable to submit in
You see, issue number 2 is the suit maintainable in its present form? 2 is that. Issue number 2.
Yes.
And 1, 2, 3, you have not argued such.
Nobody has, lordship. Nobody has. So, my lord, this decree was
challenge this decree.
Lord, kindly, my lord. There are judgments. I am supported by judgments of very recent judgments of the Honorable Court.
Nullity. Inherent lack.
Lordship.
Inherent lack.
2022 1
inherent lack of jurisdiction.
2022 1 CLJ. No, lordship. So, well, this decree was specific. Kindly see the findings once.
Yes, you have seen it. It would
that you are to retain this land by kindly 62. Kindly,
Mr. Khalid, this is a legal error. We should have taken 1 minute to set it aside, but you didn't come to us.
No, lordship.
In a civil appeal.
This is one. Well, there's one part.
BLRO cannot. If the BLRO starts disobeying civil court's orders, Mr. Khalid, it would be a dangerous precedent.
No, but thereafter, my lord,
prefer an appeal.
Thereafter, my lord, kindly see what has happened, my lord, thereafter. My lord, thereafter, kindly sees. In the meantime, so yes, my learned friend comes to Honorable High Court, page 38. Page 38 is Honorable High Court's order in the year 1983, my lord, 38. 39 is the finding. Having heard the learned advocate for the parties, direct the concerned respondent to dispose of the representation for correcting the record choice in accordance with the judgment and decree. Complete. In the meantime, what happens? 1978, my lord, there comes a 14T3 proceedings. My lord, it was challenged in High Court by my learned friend's predecessor, Abdul Wahid. Kindly see what was the finding of the Honorable High Court at page, my lord, 64, my lord. Lordship 64?
64.
Lordships. Kindly see page 65. Who was the petitioner? The predecessors of my learned friend's client, Abdul Wahid Mondal. Kindly see the finding. My lord, page 65 at the bottom. Having heard the learned advocate for the petitioner going through the petitioner and the supplementary affidavit, I quashed the impugned notice and sent back the case to the revenue officer for rehearing the same in accordance with law after hearing the petitioner and by passing a reasoned order within 2 months from the date of communication of this order to the authority concerned. The petitioner is also given liberty to agitate before the revenue officer all the points taken in the present civil order and file a list of his own lands. And the revenue officer, while disposing of the said case afresh, is to consider the quantum of land to be retained by the petitioner on the basis of such list to be supplied by the petitioner and will not take into account any extraneous matter or tag any land belonging to any third party or acquired by the state to inflate the total area of the lands of the petitioner. The petitioner will also be at liberty to show before the authority concerned the lands of the petitioner are not in the irrigated area and the authority concerned to decide all the said questions as per the provisions of 14N of the Act. 14N is LR Act.
What
Till
was
such
their
disposal
application?
report-
It is not stated in this order as to what was their writ petition for.
Writ petition was for because when the 14th
What was the notice under? Which was-
under section 14D3 was to start, that was under challenge and that was quashed, directing the big riot, you go and participate in the proceeding.
But this was after the decree.
Yes, that was in the year, yes, that was in 1989. So this is the, thereafter what happens?
Writ court order cannot override. This is, no, right. It has been decided only. They have been asked to go there.
Lordship, kindly, my lord. So now this 14D3 commence and concludes. Lordship will find the findings at internal page 2 of the impugned order. What happens in that 14D3 proceeding, kindly sees Lordship.
Yes.
Kindly take some, my lord, the impugned order.
Yes.
My lord, that is at page 134. The internal page 2 is 135, my lord. Kindly sees, my lord. Only that relevant portion I will be, my lord. That sentence starts with, in terms of the said order. Lordship got the sentence. In terms of the said, plus the fact of the case paragraph. Add into 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 lines from the top. In terms of said, some plots of land were recorded in the name of the applicant's father, but in the meantime, by virtue of another proceeding under section 14T3, be the case number so and so, arbitrarily vested 8.41 ideas of land in favor of state from the coffer of the riot, challenging the said order. Another petition 8576 was filed. 8576 was initiated by riot, wherein the Honorable High Court, by its order date is, this is the order, 9th November 19.
They also did not point out the decree.
No, Lordship, no.
Then they
So,
submitted to the jurisdiction of the revenue.
yes, Lordship, kindly, my Lordship. Now, so in terms of that, they started by quashing the impugned notice of the proceeding of vesting and send back the case to the revenue officer for de novo hearing in accordance with law and to pass a reasoned order. De novo hearing was made and a fresh order of vesting was issued, but it was revealed that the said compliance proceeding was disposed of by the revenue officer ultimately by vesting 0.84 acres of land to the state, for which the earlier order of vesting of 8.41 acre would be reduced by retaining 7.5 acre of additional land in favor of the applicants. But ultimately, the record was not corrected in the present LR record of operation by inputting additional quantum land retained in the name. So this is submitted to the jurisdiction. 14T3 completes. This is the retained part is 7.57 and rest is with the state. Now comes the second chapter, again one 14T3A proceeding. Revision part. Notice comes. What is the where is the notice? Page 94. Kindly see, my lord. Second episode starts. My lord, 94, my lord. This is upon.
Let us just complete this and then we'll complete the order of the tribunal.
No, juxtapose if I place, Lordship will be able to, my lord. I can clarify, Lordship.
94, yes.
Yes, 94. This starts against the heirs of the Ohed, the present petitioners, for a determination or redetermination under Rule 14C of the Land Reforms Rules. This notice, he challenged. This notice, kindly note the date, 1st January 2001. 1st February. This comes for challenge. Where? Before the tribunal. Kindly comes to page 95.
Land Reform Sector. Thank you. 1 second.
So for
এখানে থাক.
Yeah, my lord, State Acquisition Act, land reform, or should be, my lord, in front of your lordship, my lord. This is the second 14.3 comes up. Notice is page 94, 1st February 2001. Lordship got this? Oh, Lordship.
This is actually a 14T6 scenario should have been. No, there was no determination. This is the first determination.
Determination and redetermination also can take. I'm sure. Yes.
Determination under 6, subsection 6.
3A revisable. 3A is revisable and kindly see 14C. What are we talking?
Yes, revisable.
Give me the big book.
3A revisable. Right.
Lordship, kindly see the annotated book. Rule 14. 14C. Lordship has the annotated book. LR Lordship.
Anyway, let us continue. We'll go into that.
Kindly see 14C. There is a power that even after completion of first 7A form, 7AA form can come up for a determination or redetermination.
Has to be another section.
Lordship.
Rules are governed by the sections.
Lordship. So 3A read with 14C. Now comes, my lord, this second notice 94. Lordship, kindly, I'm on the fact now.
Right.
This second notice comes against the AS.
Not under 14.3, not under 3A, because this was the first determination. There was a previous round.
14.3, but 7AA proceeding. Form 7AA. There are two forms in 14C. That is why I'm bringing the this annotated text. The original B form is 7A, and thereafter 7AA form can be invoked, can be called for. বইটা ছোট বইটা ছোট বই এলার একটা 14T3 my lord.
Yes. 14T3 is there.
Lordship is well very much conversant with this.
14.3 is the first instance when it is
Yes, then comes 14.3A, followed by 9. Lordship is on the other day. Lordship is very well that res judicata will not apply, and notwithstanding this, and the Lordship is in that subsection 9, and subsection 9 takes care of 5, 6, 7, and 8 also.
But this was under 3A. 9 is regarding 5, 6, 7, 8.
Yes, can reopen and decide afresh.
3A is revenue of
revisable power afresh.
Revision order made under yes, that can be only an order made under subsection 3. There was no subsection 3 order at all in this case.
Earlier it was there. Then that first 14T3.
Yes.
Determination was there. You keep this retained land and these are vested.
That notice was set aside, and sorry, we forgot. The tribunal sent it back. Then there was a fresh determination under in his predecessor's
High
name.
Court set aside the notice, sent back,
yes.
Determined, finalized.
Finally held, it was vested. That
Yes.
was challenged before the LRTT.
No, that was not. Rested in peace. Then comes second notice upon the
So
heirs.
his predecessors, the order passed against his predecessor under 14T3 remained.
Yes.
That was passed after the civil court's degree.
After civil court's degree in compliance with the High Court's order.
All right.
Because High Court, Honorable High Court was specifically, you start afresh.
You started and you culminated, and it was
You
vested.
go participate, he participated, culminated. That culmination I read out from that internal page 2.
Yes.
That you keep 7.57.
Second round of litigation again given to them, again determined.
14 seat 14 seat. Land reform rules. Rules. Milord 14C, milord. 14C, may I read out or shall I hand over?
We have
14C is the form and manner of submission return under subsection 1 of 14T. The return to be furnished by a Rayat owning land in excess of ceiling area shall be in form 7A. First, the return shall be submitted in triplicate within the 31st day of July.
Kali, the rules do not override this statute. So we want to see the parent provision under the statute under which you did this, because you stated there 14T3. 14T3 cannot be done twice. 3A we can.
No, 14T3 can be done twice, provided first there can be a redetermination also.
That is under 3A. Let us read 14T3 together. Section 14T3. T3 and 3A together. 3 is the first exercise. Three does not give the power to reopen or redetermine. That is done under 3A. 3 says revenue officer may on receipt of return or on own motion determine the extent of land. 3A says revenue officer may of its own motion, etc. revise an order made under subsection 3 and determine afresh. So 3A gives that power. You gave the notice, the fresh notice was under T3 again. You cannot do T3 twice. And it's not covered by 14T9, which does not protect T3A. T3.
Yes, Lordship.
T3 is not protected. 5 onwards it protected.
Lordship.
3 can be reopened under 3A.
But
You never gave a 3A.
it has used 14.3, whatever, but it should have been 3A, Lordship. But 14C was the notice. They have 14C clearly says you can retire.
14T3 you gave a fresh notice to these people, the heirs.
No, because rule 14C.
No, let us understand this. You gave a fresh, after the previous adjudication in the name of his predecessor, you gave a fresh notice under 14T3. As the tribunal says, they challenged that before this court. That was set aside again, sent afresh probably in a writ petition. Let us come to page 2 of the internal page 2 of the. That's
no,
why say,
internal page 2, my lord. This completes
let us complete the order of the tribunal, Mr. Galip. Then we will look into papers.
Achha. My lord, then 7.57 acres of additional land in favor of the applicants, but ultimately record was not correct in the present LR settlement operation by including the additional quantum land retaining the level. After demise of the father of the applicants became the legal heirs and successor of the deceased big right, and the bona fide recording owner of those land in question, but it was observed that the revenue official issued a notice under section 14T3 of the date with 14C1 by starting a case under 7AA, VDate 20 of 1992, dated 1st February 2001. The direction to the applicant to remain present for a hearing, fixing date for hearing, so and so. Challenging the said notice, the original application was filed before this tribunal, VDate 393 of 2001. In disposal of the said way, Honorable Tribunal, after passing some observation, have finally disposed of the same with the direction to the applicants to appear before the revenue office in order to raise all the points that have been raised before the tribunal, and the revenue officer were directed to hear the applicants and disposed of the case in accordance with law. Though the applicants appeared before the authority concerned, submitted all requisite papers, judgment of the Civil Court, Honorable High Court, Calcutta, opportunity of correction in favor of them was not considered on the ground that unless the superior authority is directed, no divesting order can be issued for recording the additional quantum of land vested in favor of the applicants. Therefore, DL and LRO issued a letter dated 20th September 2017 to file an application regarding this case before the BLR memory for correction of record of rights. In spite of receipt of the same, the authority concerned did not correct the record after divesting from the land from government khatiyans in favor of the applicant's hearing. An action on the part of the authority concerned is illegal, arbitrary, intentional, and without following the process, the authority concerned should be directed to comply with the same. So it means second, this 20 of 1992, it comes, my lord, on the basis of page 94, which I had shown your lordship. This 94 is the notice for the second 14T, and kindly say learned tribunal says about one way 393. This lordship will get a 95, page 95. What was that way for? That in that way, these present petitioners challenge the notice or at page 94. That is the notice of second 14T3. Am I clear to your lordships? Page 94 was.
Let's complete the order first, tribunal.
State stand, learned government appearing on behalf of the state on the contest submit this application not maintainable. A jurisdiction of civil court in case of any proceeding for vesting and delimitation of barred, and any direction passed by the any court of law with direction to comply with the order of civil is a nullity. Furthermore, learned government represented by citing a judgment of Justice Putapre WPLA Tiswan submitted that the verdict mentioned in the said case WPLA 29 is similar to the present original application nature, wherein the Honorable High Court in disposal of a case filed before challenging the order of the Honorable W passed in way number so and so, allowing amendment so and so, had observed the writ application stood dismissed as there is no ground and merit to disturb the impugned order passed by learned tribunal, which in its final disposal order has observed that if the applicants have any grievance against the order passed in case number so and so, there is provision for filing appeal under section 54. Hence, at this stage, the application filed before this tribunal is premature one. Hence, the present original application being filed with skipping the forum is also void ab initio, liable to be dismissed. Now, observation, peruse the record meticulously. After close scrutiny of submissions made in the original application and a chronology of events reported therein on behalf of the plaintiff, we observe applicants have neither submitted any proper representation before the BLA concern in compliance with the order of this tribunal of 393 of 2001, dated 7th February 2001, with relevant documents, and appeared before the BLLRO in reply to the notice for a proceeding under section 14T, 3 of the WPL Act 1955, challenge therein. Hence, the application for inaction does not lie. Furthermore, the applicants have not spared a single line to clarify its necessity to skip the forum by not availing of the relevant opportunity of filing appeal under section 54 of WPL Act for DLLRO as provided under the Act, but to file this application directly before this for adjudication. Hence, the applicant have not uttered a single sentence by mentioning the fact which prevent them from filing an appeal. So, Miller, the conclusion is that you go before section 54 authority. Why before me? Since this miscase number under section 7, it should be not rule 7 VD 20 of 1992 was initiated, but as of now, I did not get an instruction whether this particular miscase of 2092 stands concluded or not. Because until concluded, how can it be sent to 54? 54 appeal lies only, does not lie against an interim order. So I was seeking for instruction, but they did not give an instruction as of now that whether this particular miscase, this under rule 7 was concluded. Had it been concluded, my lord, there should be 54. But I'm not sure even there is no reflection of the instruction of the learned from the submission of government representative also before the learned tribunal. So this is the case, Lordship. So, my lord, this Lordship, this second
two things you are telling you, Mr. And one is that the rules only operate under the provisions of the main statute. Rules cannot override the main act. Rule, yes, 14C is there. 14C contemplates two scenarios, 17A, 17AA, state government may direct. But we have to read the rules in terms of the provision, parent provision in the statute. Parent provision under 14T3 gives a right for the first determination. First determination was done in respect of this plot during the era of his predecessor in interest, which is a good ground you have. We'll deal with that later. Secondly, the second reopening of that could only be under section subsection 3A. You notice what under 14T3, and we are not sure whether that exercise has been concluded also, as you are saying.
My learned junior also.
No, he is unable. How can he? He's
in the morning also. I had a discussion. No. As of now, I can't tell what
we cannot say. Yes. We cannot say that exercise, according to us, is not prima facie. Is not. But anyway, it was the High Court was approached, and one round of litigation is there. It has been sent down for adjudication. But in that adjudication, they may take that point if it is still pending that second 14T3 is not applicable. 3A could have been. But still, fact remains that the predecessor in interest order still remains. The 14T3 adjudication in their favor where they submitted after the decree of the civil court. And you may very well argue that civil court's decree is not res judicata because res judicata section 11 says court of competent jurisdiction. Civil court was not competent. So inherent lack of jurisdiction, you say it may be treated to be a nullity, at least not a res judicata in any further proceedings.
And thereafter, he submitted to the jurisdiction of 14T3 authorities and finally done.
His
first 14.
Yes, that is what we said.
Yes,
we are on that only. The second round is not so palatable to us. 14T3 for the second time is no.
Notice is under 14T3 and rule 14C. It says, and even tribunal is referring to rule 7A as.
But if it's pending, they can still take that point before the
first
authority. That will not go into that because none of you are sure whether that is still pending or not. But
no, but in the way he has paid for injunction. That
we are deciding it. Where is it?
No, in the way he has
in
the way petition, he has prayed for an interim relief that this miscase 20 and 90 should not be proceeded with. He prayed for injunction the day he filed this original application before tribunal.
That in any event.
So, Lordship.
No, inaction probably on the ground that.
What was the challenge in way? May I show you?
That in the first line, the original application has been filed for inaction on the part of the BLRO. Yes. In the matter of compliance with the order of the civil court.
Even when in constitutional of my application is also there.
No, that is his way is for that only, not for injunction.
Yes.
No question of injunction. He says there's a civil court decree, comply with it.
Lordship.
That was
not because, but what the tribunal looks into is there is a subsequent to the civil degree, there is a submission by them, their predecessor, to the jurisdiction of the BLLRO under the statute, and there has been an adjudication on that.
yes.
And that is, they are also bound by that. And that is within jurisdiction, whereas the civil court's degree was without jurisdiction. We searched in vain, but the civil court degree does not contain any declaration of title. There are a line of judgments, Mr. Galib, which say that if declaration of title is sought consequentially by way of consequential relief, civil court also can grant, yes, records of right corrected according to the decree, declaration. And that was precisely the case in the cited case by Mr. Hussain. There was a civil court's degree, title was
You are
declared
bound to follow it.
consequential. That is permissible. But the way it was done straight away, we are also not convinced so much. But we were on the issue of whether the civil court degree. But you have a point there, and since they themselves, their predecessors submitted to the jurisdiction, so that is the limited. We will ask.
And that has completed long ago, and thereafter they are before on the second 1433 proceeding, they came before tribunal. Tribunal again asked them to submit before the jurisdiction of RO. They did not go. So the second part is concerned.
Achha, what is the judgment you are going to cite
Regarding?
You said we don't know.
No, Lordship, it is bar, my lord, with regard to
bar is by the statute. Bar is definitely there. Civil court cannot.
So, my lord, one bar is under section 14X of the Land Reforms Act. Another is under section 61. These are the two provisions, my lord. On these two provisions, my lord, may I respectfully submit, my lord, cite, my lord, two judgments. Pat on the point, there are two judgments, my lord.
Cite.
May I, my lord, assist your lordship, my lord?
Please.
My lord, first judgment is, my lord.
পালা করে করে আসছো না, একবার তুমি আসছো না, একবার আসছো।
This is, my lord, 2022, my lord, 1 CLJ, my lord. This is on 14X. Page, my lord, 178. ঘাঁটবে না কিন্তু একটা পর একটা আছে। এসো এদিকে এসো। Kindly seize, my lord, this was the
This
issue.
is precisely what we are saying.
Precisely paragraph 5.
No, not that. Here a challenge was filed against the civil court's decree.
And jurisdictional point, which my lord was pleased to ask me, that you never took up the jurisdictional point before the suit court.
No, inherent lack of jurisdiction can be taken.
Here,
against
that's the
it.
same issue not taken up.
That's settling.
Then 5-6, and kindly seize, my lord.
This was an appeal against the civil court's decree, Mr. Galib.
On the issue of vesting under 14T.
Yes, but his degree has attained finality here. Even if without jurisdiction it is attained finality, you never preferred any challenge against that. You also submitted to the jurisdiction there first, before reopening this issue before the appropriate.
And honorable division may say, even if you have submitted but have not raised the issue of jurisdiction.
We are not on that at all, Mr. Galib. Why should you say, repeat, go on. If a jurisdiction, inherent lack of jurisdiction is not raised, it's a pure question of law, can be raised any time. Everybody, every law student knows that. But the question here is different. You never took that point in first appeal. If you prefer, that is what you started with. That if we were sitting in appeal, it would not survive a minute, the trial court's decree. But never, no appeal was preferred by you. It was a contested decree. This is a peculiar scenario. Jurisdiction point, yes, at the outset you could not have taken. But can you just deny a decree of a civil court? Your best point is res judicata is not applicable because section 11 contemplates a court which the court passing the initial degree had to have competence. Competent court competent to try it. Civil court was not competent because of 14X.
Lordship.
Or 61, whichever it is.
61.
Any other judgment? You are going to say two judgments, you said. On the same point, that must
on
have been
61, on 61 there is a
that must have been also an appeal from the civil court's decree.
No, 61 judgment is by the Honorable Supreme Court.
Yes, arising out of must be a challenge to a civil court's decree.
No, that point was not never taken by the state. 2008, volume 17, SCC, page 66. Now, kindly seize me, paragraphs 5, 8, and 9. Honorable Supreme Court is pleased to relegate the matter, directing the parties, you go and take remedy under section 54.
Absolutely. Civil court's degree was challenged in an appeal. From that second appeal against that this.
Yes.
But here we have to go one step further, holding that civil court's degree was a nullity, therefore cannot be executed.
And secondly, he has submitted to jurisdiction of 1483 thereafter
Predecessor.
in compliance with the lordship. And we know this subsequent 1483, 14T can be a continuing cause of action. It can start second time also, my lord, because lordship
Today you decide under section 14T3.
this one which is pending, or we are not sure of whether it is.
No, 14T3 you decide finally. Tomorrow then you can start another 14T3 till never end.
No, lordship. I'm not on
Don't
that.
have that power, Mr. Gali.
No, lordship.
You cannot raise forever unless it's under 3A.
No, lordship, I'm not on that. Since today, as on date 114T3, they have written 14T3 in the notice, but it should have been 14T3A read with rules 14C.
These are two different provisions. This is not a question of wrong capture.
No, lordship. Now, my lord, as on date, this Miss 20 of this latest one, whether pending or concluded, we don't know. But lordship, this, my lord, since there is no res judicata on the issue of sealing laws, lordship knows. And my lord, there is, I don't know, on the last occasion, lordship was hearing one matter on this point, lordship reserved judgment on that. There is a judgment of Supreme Court also that on sealing laws, there cannot be any res judicata. Apart from subsection 9 of section 14.3 we have.
Because in the context of 5 to 8, which is covered by section 14T9. This is not a 14T5 to 8 scenario.
No, but in here in general observation, the Supreme Court is telling
9, if subsection 9, that is by virtue of section 14T9 and nothing else. 14T9 specifically provides no res judicata will operate from 5 to 8.
Or any decree.
Thereby implying, by necessity implication, for the others, res judicata is applicable.
But in this judgment, if I may respectfully cite, my lord, just, my lord, I don't know whether you will be any assistance or not. Here, my lord, taking into account of some UP selling laws, Honorable Supreme Court, my lord, has been pleased to.
Any other judgment apart from this?
Pronounce.
How many judgments total?
No.
There is same point only one judgment.
No. Yes, certainly.
Yes.
My lord, kindly, my lord, seize, my lord, paragraph. This is 2004.
Give the reference and for Mr. Hussain.
4 SCC 281. Paragraph 52. Now, which 52 placitum G part, kindly seize lordship. Placitum G. All principles of res judicata contained in section 11 CPC cannot be strictly and rigorously made applicable to sealing proceedings. In paragraph 53, my lord, may I respectfully invite your lordship to placitum E part. Placitum E. On these admitted facts and nature of title of the land, plea of res judicata cannot be allowed to be raised. The case initiated and proceeded with in sealing law is not an adversarial litigation between the state and the landowner. It is enforcement of a social welfare legislation act in accordance with the directives of state policy in Article 39 of the Constitution. And, my lord, 54, my lord, the plea of res judicata has been held to be barred in proceedings under sealing laws in decisions of Allahabad High Court. This one. And finally, my lord, only paragraph 56. Paragraph 56. In view of our above discussion on the issue of applicability of doctrine of res judicata, it is not necessary for us to deal and discuss cases cited by the counsel for the parties in the power of the appellate court by invoking provision order 4133 to hold the land of school as included. So, my lord, this is, my lord. So, my lord, this.
No.
I am on second 14.
Court was looking into the virus of section 38B of the Sealing Act. court held it is like 14T9.
9,
Similar provision was there.
9,
That
9,
was challenged.
9.
And court says that ambit and effect of provisions of section 38B imposing bar on the plea of res judicata came up, decision was taken. No, that is not ultra virus. And that's true in a sense, Mr. Gal, that is precisely what we said in the that matter, other matter also. That res judicata, an argument was raised, the principle of res judicata is sacrosanct. And no legislation can be passed on that. And that is precisely what we said, Mr. Galib, that res judicata is a concept of law. By legislation, the legislature can may or may not adopt the principle of res judicata in certain aspects. Like in criminal law, it's not applicable.
Lordship.
Legislature may do that because it is the representative of the people who do that.
Lordship.
Not us. We are not representatives. We are not elected. They can.
But
do
your
that.
lordships take oath by the same constitution.
Maybe. But we don't create law. High courts can't. 141 Supreme Court can. We can't. Therefore, we are bound by the law. Legislature, when we are considering executive action, the action of the state, Mr. Gali, we have more liberty. If it's violative of certain constitutional principles or basic doctrines which hit our conscience, we can set aside. But hitting the conscience may or may not apply to a statute. By statute, things can be done to reflect the aspersions of the people, which we have to go on a very high taste if we have to hold a statute, a legislative provision to be ultra virus. It has to be a very high standard, not doctrine of res judicata of not that stature. It's a doctrine, definitely it's a very valid doctrine, but may not be applicable. Legislature may make it not applicable. 14(9) was that. This 38B was that. That was upheld. But their legislature, by introducing that provision, Mr. Gali admits that, legislature admits that regarding the others, because 14(9) says for 5 to 8, res judicata is not applicable. The moment you have to say that by you have a provision in this statute, in this section, means that for the others it is applicable. That's implied, that's necessary by necessary implication. So 3 res judicata, we are not happy with that, but 3A is the provision which has been introduced to bypass res judicata. And 3A virus, we are not on that.
Lordship.
We're not saying it's ultra virus. We cannot say that.
One in respect to reply, my lord, to your lordship's, my lord,
Yes.
statement. Yes, it is certainly, my lord, this section which was challenged before the Honorable Supreme Court in tandem with subsection 9 of 14T3, lordship. But in respect to reply only, my lord, kindly sees para 53, placitum E. It takes a general view that in sealing law, since it is with an avowed object of meeting Article 39, this is one of the aspects also touched upon by the Honorable Supreme Court in paragraph 53, placitum E part.
Please come to para 52, Mr. Gali.
52, lord.
Para 52, placitum G also. In applying the principles of res judicata, therefore, to the sealing proceedings, the object of the act cannot be lost sight of.
Lordship.
All principles of res judicata contained in section 11 cannot be strictly and rigorously made applicable to sealing proceedings. This is the key provision. All the rest is a follow-up. So, therefore, in applying the principles of res judicata, therefore, to sealing proceedings, the object of the act cannot be lost sight of, and all principles of res judicata contained in section 11 cannot be strictly and rigorously made applicable to sealing proceedings. So that has a different flavor.
Meaning, level and flavor.
Saying that it cannot be said to be a blanket bar. Otherwise, Mr. Galib, it will be ridiculous. Today, you finally observe under 15T3 that yes, this land is vested. Tomorrow, I can go up before you and say, no, you are not barred by res judicata. Very next day, I can file an application and you have to re-adjudicate that again also. See the converse of it. If the state can do that, the Rayat can also do that. And the others can also do that.
Lordship.
Or the state. Then state will be utterly high-handed, Mr. Galib.
Lordship. And all through, my lord,
there's a
shoot
final...
out tomacles on the head of the citizen.
Yes, democracy sword. And today is finally decided this land is not vested. I have the right to retain. I go home, sleep at night, come back tomorrow morning get a notice. No, 14T3 again. Again I lose. It's like those games of chess with children. I mean, first is a best of 3, you lose twice, becomes a best of 5, you lose thrice, becomes a best of 7, like that. You cannot do that to a legislation. You cannot have repeated hearings and repeated adjudications. There has to be a finality. That is the principle on which 5, 8, those have been protected by 9, but not the others. So 3A we understand.
So, my lord, here the notice, the second.
We are going on a basic point. The basic point is that they have submitted to the jurisdiction. Not only that, that It was not res judicata because it was the civil court was not competent.
And second 14T3 notice, my lord, which your lordship was, I have.
That were minded to set aside. We
94.
cannot from here, you are lucky on that.
No, lordship, but as on date, what is the status of the proceeding also?
We will tell you that.
No, lordship, lordship.
Yes, Mr. Hussain, what is your reply to that? Civil court was not competent, passed a decree. It's a nullity in the eye of law, inherent lack of jurisdiction. Not a territorial question, not a pecuniary question, inherent lack of jurisdiction. One, if it's not res judicata, then it can operate anywhere. They can do it. One. Secondly, your predecessor submitted to the jurisdiction and there was an order. So why should he now honor the civil court's decree because you yourself did not? You submitted to the jurisdiction, your predecessor. But how can we reopen the second order which was passed after the civil court's decree? You also submitted to the jurisdiction. And this would be, I mean, a bad precedent also. Just like we are telling Mr. Galib that if a civil court's decree is disobeyed, but you yourself submitted subsequently to the jurisdiction and adjudication was made, you did not challenge that also. And civil court's decree civil court was incompetent in subject matter jurisdiction, not in pecuniary or territorial. So let us uphold the order. We will discuss your judgments right now. The present challenge has been preferred against an order passed by the Land Reforms and Tenancy Tribunal, whereby the tribunal turned down an application filed by the writ petitioners alleging inaction on the part of the concerned BL and LRO in not correcting the records of right, thereby reflecting the adjudication made in favor of the petitioner's predecessor in interest by a competent civil court. Full stop. Learned counsel for the appellant petitioner submits that the civil court's decree was a contested one and never challenged before any competent appellate court. Full stop. As such, the same has attained finality. Full stop. Next para. Accordingly, the subsequent exercise undertaken by the state in issuing a fresh notice under section 14T within bracket 3 of the West Bengal Land Reforms Act 1955 are bad in law, and the BL and LRO had to honor the decree of the civil court. First of learned counsel cites a division bench, a coordinate bench judgment of this court in the matter of Pashupati Das versus BL and LRO, reported at 2011 3 CHN bracket Cal 13 for in support of such proposition. Full stop. Next para. Learned senior government advocate controverts the allegations made on behalf of the petitioners and submits that although the civil court's decree was passed in favor of the predecessor in interest of the present writ petitioners, subsequently a notice was issued under section 14T within bracket 3 of the 1955 Act by the appropriate authority. Full stop. The notice was challenged at the first instance in a writ petition before this court, which was allowed, thereby setting aside the notice, but relegating the predecessor in interest of the petitioners to the self-same forum. Full stop. Subsequently, the predecessor in interest of the petitioners submitted to the jurisdiction of the BL and LRO, and there was a competent adjudication under section 14T within bracket 3 of the 1955 Act. Full stop. Next para. After the demise of the predecessor of the writ petitioners, another notice was issued, purportedly under section 14T within bracket 3 of the said Act, read with the governing rules of the connected rules. Full stop. Next para. The said notice was also challenged at the first instance, but in this case as well, the writ petitioners were relegated to the appropriate authority. Full stop. However, senior government advocate submits that he is not properly instructed as to the outcome of the second round of section 14T within bracket 3 proceedings. Full stop. Next para. Learned senior government advocate cites a division bench judgment of this court in the matter of Chobirani Pal and others versus State of West Bengal and another, reported at 2022 1 CLJ bracket Cal 178 for the proposition that the civil court is not competent to decide whether a land has vested in a person. Full stop. Next para. Learned senior government advocate also cites the judgment of such and such, Namta Didio, reported at 2008-17 SCC 66, in support of the self-same proposition, full stop, whereas, in the division bench judgment, comma, the operation of section 14X of the 1955 Act was being discussed, comma, in the judgment of the Supreme Court, comma, indicated above, comma, the bar under section 61 of the 1955 Act was under consideration. However, comma, it is submitted that the proposition of law remains the same in both, comma, to the effect that the civil court is not the competent forum to decide such proceedings, comma, with which powers the authorities under the 1955 Act are categorically vested. Next para, learned senior government advocate then cites escorts firms, etc. Namta debe, reported at 2004 SCC 281, where it was held by the Honorable Supreme Court that the plea of res judicata has been held to be barred in proceedings under sealing law. Next para, citing the same, comma, in particular paragraphs 52 to 56 thereof, comma, learned senior government advocate categorically cites that the principle of res judicata being not applicable to sealing acts, comma, as held by the Supreme Court, comma, the decree of the civil court cannot be construed to be binding, comma, in order to deter, DETER, the appropriate authorities under the 1955 Act to reopen the proceedings. Next para. Upon a careful consideration of the arguments of the parties, comma, we find ourselves unsure as to whether a second exercise could be undertaken by the state authorities under section 14T within bracket 3 of the 1955 Act in respect of the present writ petitioners, comma, once a conclusive order was passed under the self-same provision in respect of the self-same proper land with regard to the predecessor in interest of the writ petitioners. Next para, although section 14 within bracket 3 capital A of the said Act permits the revenue officer to do so, comma, the notice issued at the second instance was under section 14 within bracket 3. Next para, the double inverted the wrong caption, double inverted clause theory does not apply, comma, since a substantive provision of law was categorically assumed by the authorities in issuing the notice. Next para, we also take note of the fact that although subsections 5 to 8 of section 14 capital T have been protected in respect of operation of the principle of res judicata by subsection 9 of section 14 capital T of the 1955 Act, comma, the said protection, comma, by necessary implication has not been extended to proceedings under section 14T within bracket 3 of the said Act. Be that as it may, comma, since we are not apprised as to the outcome of the second proceedings, comma, these questions should be, comma, in any event, comma, left to be argued by the writ petitioners before the appropriate authority, and we desist commenting on the same on merits. Next para, however, comma, the more disturbing feature of the matter is that the state, comma, despite suffering a civil court's decree, comma, never preferred an appeal against the same. The judgment of the division bench in the matter of Chobirani Pal was in connection with an appeal preferred against a civil court's decree. The division bench held in the said judgment that the point of subject matter jurisdiction hits at the root of the jurisdiction of the court and can be taken at any point of time, comma, even if not taken at the first instance before the trial court. However, comma, we cannot lose sight of the fact that the challenge before the division bench was against the civil court's decree itself, and while sitting in judgment, comma, the appellate court has extensive powers under various provisions, comma, including section 107, comma, order 41 rule 23 and order 41 rule 22 and order 41 rule 33 of the Code of Civil Procedure in reopening all issues and passing decrees as it deems fit. Such luxury, comma, it is arguable whether such luxury, comma, whether available to the BL and LRO or this court, comma, in the absence of a challenge to the civil court's decree, comma, is to be considered. Next para, insofar as the judgment rendered by the Supreme Court in Hari Mohan Dana, DANA, Dana's case, comma, the same logic as recorded by us above applies, comma, since the challenge pertained to a decree passed by a civil court in the first instance. Full stop, next para. Thus, comma, we are of the opinion that those judgments are not binding precedents insofar as the present question is concerned, comma, as to whether such a decree, comma, passed by a civil court without jurisdiction amounts to a nullity, comma, which can be avoided even without challenging the same in appeal. Full stop, next para. The judgment of Escorts Farms FARMS, comma, cited by the learned senior government advocate, comma, observes that considers the objects of a sealing act of the sealing act, এটা ক্যাপসে করবে, comma, considering the scope of a particular statute. Full stop, while holding so, comma, it was held that it was observed that proceedings under the Sealing Act are not adversarial as are proceedings in suit. Full stop. It was observed by the Honorable Supreme Court that the laudable LAUDABLE social objectives sought to be achieved by the sealing legislation is to take surplus land from the holders and distribute the same to the landless agricultural laborers and peasants surviving on agriculture. It was observed specifically that in applying the principles of res judicata, comma, therefore, comma, to the sealing proceedings, comma, the object of the act cannot be lost sight of, full stop. The Supreme Court categorically observed that all principles, double inverted mode, all principles, double inverted clause, of res judicata contained in section 11 CPC cannot be, তারপর double inverted মধ্যে strictly and rigorously, double inverted clause, strictly and rigorously টা double inverted মধ্যে, made applicable to sealing proceedings. Full stop. However, comma, the premise of such observations was in the context of a particular statute and not any sealing law in general. Full stop. More importantly, comma, the Supreme Court observed Supreme Court did not observe that the principle of res judicata was barred in a blanket fashion in respect of all statutes where sealing limits are the subject matter of the legislation. Full stop. The reason for the same can be found from the context of the judgment, which was in respect of whether section 38 capital B introduced by an amendment of 1976 in the statute under consideration there, comma, was valid, comma, since it imposed a bar on the plea of res judicata in civil proceedings. Full stop. In such context, comma, the Supreme Court rendered the above observations. Full stop. Next para. A similar, comma, perimeteria situation would have arisen if the virus of section 14T within bracket 9 of the 1955 Act was under challenge before us, where, comma, the Supreme Court's said proposition would be completely German. Full stop. However, comma, subsection 9 of section 14 capital T categorically protects only orders or actions taken under subsections 5 within bracket to 8 within bracket of the said section, comma, therefore, comma, by necessary implication, comma, omitting to extend the benefit of avoidance of res judicata in respect of the other subsections, comma, including section 14T within bracket 3 of the Act. Full stop. The said judgment, comma, in our case, comma, might have been relevant in the context of the subsequent proceeding initiated against the present writ petitioners, but is not germane for the question at hand, comma, which is whether the decree of a civil court is operates as res judicata in a subsequent land sealing proceeding. Next para. Moreover, comma, in Escorts Farms case, comma, the Supreme Court was considering an inter se operation of res judicata in the sense whether an order of the appropriate authority under the Sealing Act would operate as res judicata in a subsequent proceeding by the self-same authority under the self-same statute. Full stop. Here, comma, however, comma, we are dealing with the decree passed by a regular civil court, which is not covered by the principle laid down in escorts firms. Full stop. Next para. While considering the same comma, we cannot lose sight of section 11 of the Code of Civil Procedure, comma, which categorically preserves the right, preserves the operation of res judicata if the civil court which passed the initial decree was within double inverted competent double inverted clause to pass the same. Full stop. Next para. The expression double inverted competence cannot be lightly taken, comma, since, comma, if obliterated, comma, it would take away a valuable right embodied in the Code of Civil Procedure. Full stop. There are several sorts of objections to jurisdiction, hyphen, primarily, comma, territorial, comma, pecuniary, and subject matter. Full stop. Next para. Whereas territorial and pecuniary jurisdictions and objections related thereto are to be decided at the outset of the suit or proceeding, comma, as embedded in the scheme of the Code of Civil Procedure itself, comma, the same principle cannot be applied to subject matter jurisdiction, comma, which hits at the core CORE of the adjudication and renders a decree passed by a civil court incompetent to do so, comma, a toothless decree and vitiated by which is vitiated by inherent lack of jurisdiction, comma, rendering the same a nullity. Full stop. Next para. Since section 9 of the Code of Civil Procedure explicitly excludes the jurisdiction of the civil court if there is an express or implied bar in a statute, and as both sections 14T(x) as well as section 61 of the West Bengal Land Reforms Act 1955 creates a specific bar to the adjudications which are to be done by an authority under the said act in respect of civil courts, comma, the said bar is an express bar coming within the purview of section 9 of the Code of Civil Procedure, comma, thereby debarring a civil court from passing such a decree which enters into and transgresses into the domain of the authorities under the 1955 Act. Full stop. In the present case, comma, thus, comma, the decree obtained by the predecessor in interest of the writ petitioners, comma, which was vitiated by patent lack of inherent jurisdiction within bracket subject matter jurisdiction bracket close, is a nullity and could have been avoided by anyone and everyone even without challenging the same in by way of an appeal. Full stop. We would have held otherwise if the error was a mere error of law. Full stop. However, comma, since the civil court did not have subject matter jurisdiction, comma, it was not competent within the ambit of section 11 of the Code of Civil Procedure, and the decree does not operate as res judicata between the parties and or for any forum. Full stop. Next para. A second aspect is also to be looked into. Full stop. The predecessor in interest of the present writ petitioners, comma, despite holding the said civil court's decree, comma, subsequently submitted to the jurisdiction of the concerned revenue officer and had an adjudication under section 14T within bracket 3 of the West Bengal Land Reforms Act 1955. Full stop. After having done so, comma, the present writ petitioners, comma, the heirs of the said person who had the adjudication, comma, cannot reopen the issue by taking advantage of a null NULL civil court's decree. Full stop. In such view of the matter, comma, we are of the opinion that the learned tribunal was justified in refusing to grant the relief sought by the writ petitioners by directing the BL and LRO to give effect to the civil court's decree by effecting the necessary corrections in the records of rights. Full stop. In such view of the matter, comma, we are unable to accept the contention of the petitioners that the learned tribunal erred in law or in facts. Accordingly, WPLRT 129 of 2025 is dismissed on contest, thereby affirming the judgment and order dated May 14, 2025, passed by the 4th bench of the West Bengal Land Reforms and Tenancy Tribunal in OA number 592 of 2024, bracket LRTT. no address to cost. Thank you.
But however, my lord, may I pray one thing, my lord, that this judgment will not bar the petitioner to take appropriate steps before the competent forum.
How?
Because
Other
we
we have held in your favor. They should pray that. Because some observations go in your favor regarding the section second 14T 3.
Obliged, Lord.
My lord, yes, my lord.
Registration application.
Registration application, but my
To
lord.
the other side. Oppose. What within time?
My lord,
What is the delay?
yes, what, my lord? This application.
Previously dismissed, restored, again.
1 rupee cost for that. For your taking the trouble of coming to court.
Well, there is no prayer for condonation, nothing. I don't know whether court fee has been paid. No other application, one substitution application, one restoration application without praying for any condonation. There is no prayer, nothing.
My lord,
Both it is beyond time, beyond 30 days.
then my lord, I shall file condonation. By today, my lord, I came across a judgment passed by the Honorable Supreme Court in connection with.
No, we have held that condonation prayer includes.
Yes, now Order 9, Rule 13, my
But
lord.
the averment has to be there. Something has to be there
My lord,
explaining
I
the
shall
delay.
file the
No,
application.
explaining the delay, is there any averment?
My lord, my lord,
Yes,
stated.
yes, there is.
And what about the substitution? Who died?
Substitution within time, my lord. That is the
Who died? The main
petitioner. my
petitioner died. I think.
lord. Died.
Substitution is in time. Substitution was filed. After the dismissal for default. The death occurred when?
Date occurred, my lord, in the,
After.
after filing, my lord.
3rd of October 2020 dismissed for default. And death when?
Date, my lord, recently. আমাদের পিটিশনটা কোথায়?
23rd of May 2025. After. So you'll have to allow the substitution first, then take up the restoration.
Yes.
We're doing it, allowing it. This is a second, this is for default.
Yes.
My lord, it has changed brief, my lord. I
I
have
got to
taken
know from their
the
back
Indrajit Mondal.
noting that
They served the back sheet also erroneously.
My lord, Indrajit Mondal, my lord, file. I have.
Dr. Mondal was.
My lord, I have transferred brief, my lord. He was an extremely aged person, my lord.
We know Dr. Mondal. We had full respect for him. But that does not mean that
No, I am not.
the client will get the benefit of that.
Excuse.
And we also respect you, Mr. Chakraborty.
Yes.
But that there is no difficulty in that. But it does not translate to
It should not be.
could not attend the chamber. No, this ground we are accepting. Dr. Indrajit Mondal could not. But he says there's a previous year suppressed that here.
What?
It's a suppression. Previously dismissed for default.
No, that is in record, my lord. That record.
Record will look into the record if you don't disclose it in your application. Do you ever look into the records? We'll do that in your matters from
No,
now.
my lord, I have not record. I have.
We can assure you, Mr. Chakraborty, in case of the others, we won't do that. But in your cases, then we'll look into the records first.
My lord, I'm sorry, my lord. I'm sorry, my lord.
কি করে দেখে নি চাষিবাসি হলে ওইটাই একমাত্র রাউন্ড কাল্টিভেশন cost saved. Can 5 of 2025 is an application for substitution of the heirs and legal representatives of the sole writ petitioner who met his demise on May 23, 2025. Full stop. Next para, since the application is otherwise in form and in time, comma, can 5 of 2025 is allowed, thereby directing the applicants as mentioned in the cause title of the present application to be substituted in place and stead of the deceased sole writ petitioner as writ petitioners in the present application, in the present writ petition, as petitioners in the present writ petition, full of the necessary consequential corrections to the cause title of the writ petition shall be carried out by the learned advocate and record for the writ petitioner during the course of the day. Full stop, next para. Can 4 of 2023 is taken up for hearing. Full stop. Although the application has been filed after about two months from the date of the dismissal for default, comma, no specific prayer for condonation of delay has been made in the prayer portion. Full stop, next para. Learned counsel appearing. What is your designation? We said, thought you have a designation. We forget designation. So learned counsel for the state.
Only.
Learned counsel for the state submits, opposes the application and submits that this is the second occasion on which the writ petition was dismissed for default and the same has not been disclosed in the application. Full stop, next para. It is further submitted that in the absence of any prayer for condonation, comma, the court ought not to allow the restoration application simpliciter. For the next para, upon hearing learned counsel for the parties, comma, we find that, comma, indeed, comma, the prior dismissal for default has not been mentioned in the application. So we deprecate such practice of the litigant, and the litigant, that is the present applicant, substituted applicants, comma, should have brought it to the notice of the court. Full stop, be that as it may, comma, regarding the other objection, comma, we deem in view of sufficient explanation in the body of the petition having been made, comma, that the prayer for restoration implicitly includes the prayer for condonation of delay in making the same as well. Full stop. Moreover, comma, considering that the original writ petitioner, comma, during whose lifetime the application for restoration was filed, comma, is an agriculturist by occupation and must have been a layman in law, comma, coming from the marginalized sections of society, comma, we approach a lenient view, we adopt a lenient view and are of the opinion that the minimum period of delay of about 1.5 months ought to be condoned. Full stop. Accordingly, can 4 of 2023 is allowed, comma, upon condonation of delay in filing the said application, comma, thereby recalling the order dated October 3, 2023, passed in WPLRT 7 of 2011, along with the connected applications bearing can 2 of 2012, within bracket old number can 9035 of 2012 and can 3 of 2019, bracket old number can 6690 of 2019. Full stop, next para. Consequentially, comma, the writ petition as well as the aforesaid applications are restored to their original file and number. Full stop. Interim order, if any subsisting on the date of the dismissal for default, stands revived from this date. Full stop. Next para. No orders to cost. আচ্ছা, প্রথম পার্ট যে অর্ডারটা আগেরটা অ্যালাউ করলাম ক্যান 5 of 2025, thereby directing the heirs and necessary corrections, thereby can 5 is allowed বললাম, thereby directing the হ্যাঁ হয়ে গেল। ফুল স্টপ। The learned advocate হ্যাঁ correction in the cause title of the writ petition as well as can 4 of 2023. You carry out the corrections, please, in can 4 also, because it's in the name of a dead person. So corrections of the cause title regarding the imputed heirs, substitute heirs in can 4 as well as main writ petition. Main writ petition, let us take up the main writ petition, Mr. Chakraborty, nothing in it.
Next, any other date.
Very well. The writ petition will be listed on August 25, 2025 for hearing.
August 25. Correction.
9, yes. The order sheet tag. Order.
I'm for the appellant wife.
I'm the unfortunate husband. Yes, ma'am.
Since you are appearing for the husband, it is indeed unfortunate, Mr. Bose. Should have appeared for the wife, but anyway, things happen in the world. This application is for alimony.
Alimony, my lord, he has filed an application for enhancement and another for enhancement of the alimony
Number one, number two.
It has to
my
be commensurate with the income of the counsel of the husband.
lord. And my lord, second is seeking implementation of the earlier order dated November 25, 2019, passed by the Honorable Division Bench, presided over by Justice Mukherjee. And my lord, third, a misstatement in the affidavit on my client, section 340. My lord, I need to file an
So
affidavit.
you have moved your case for his case for him. So you give your answers also to the.
No.
Why
my lord,
didn't you pay up?
No.
Why didn't you
my
make a misstatement?
No, my lord,
Let him move his application. Yes, yes.
Lordship, on the earlier occasion, there was directions to file reply. I am filing the reply in respect
Opposition?
of
Yes.
position.
Opposition.
একসঙ্গে নিয়ে নাও না দুবার আবার আবার আসবে আবার যাবে
Supplementary. দুটো
Supplementary.
supplementary বলুন না কেন?
My lord, two supplementary affidavits.
supplementary affidavit to opposition.
Supplementary affidavit on behalf of the respondent. There was a mistake, my lord, that had been corrected. I mentioned the matter.
Mistake in what? In which?
Mistake in
Supplementary
the-
to which?
Supplementary to the application to my to opposition.
Opposition to the alimony main alimony application.
Lordship, opposition is in it's a composite form. It's a affidavit of asset and also
In the matter
and
of
also an
declaration of asset,
opposition.
my lord, I omitted, my lord, certain bank accounts and the cash in hand.
So you
I
say it's a
meant-
bona fide mistake. You want to rectify those
Yes,
after he
sir.
points.
Yes, my lord. And my lord, he has raised a question, my lord, with regard to the statement of accounts that have been filed. So I tried to explain.
Despite you having other matters in other courts, you have to wait for him to finish.
Lordship, because this I'm not getting it today itself, so I'll need to deal with it. This opposite supplementary affidavit.
Supplementary affidavit you have not yet accepted. Yes, this is to rectify the
Yes, my lord.
mistake
I
after he
mentioned-
points out.
No. Before, prior to that.
Yes, and why I tell that it's after I point out because
Supplementary was there any previous leave?
অর্ডারটা বার করে হ্যাঁ বলিস অর্ডারটা বার করে
Precisely, Mr. De. Order.
I had taken these points in
We will
my
not take
opposition.
this. First, we are waiting for this. Whether there was an order granting leave. Otherwise, we'll hear you and then only permit them. আগে ওরা প্রমাণ করুক যে এটা কোনো লিভ দিয়েছিল তাহলে ডিফেক্ট পয়েন্ট আউট করছি তারপরে একটু ফর দ্য টাইমিং ফার্স্ট শো আস দি অর্ডার which date give us the approximate date
এতগুলো লোক আছে সেটা অর্ডার বার করতে পারছিস না এতক্ষণ ধরে
you have taken a change from Mr. Devjit Mukherjee
এটা কি দেবজিৎ ছিল আগে না
is still appearing
দেবজিৎ ছিল আমার একটু
anyway yes
Lordship, my application, there are two applications. One is CAN 4 and the other is CAN 5. CAN 4 is for CAN 4 is for enhancement of the maintenance granted earlier. And CAN 5 is for implement.
Very embarrassing situation for me, my lord, to make a prayer. My lord, another court may not giving adjournment. I'm coming, my lord. তুই পারবি না সামলাতে
we'll take the opposition and reply we'll record your presence
Sorry,
and
my lord, I'm extremely grateful.
Mr. Basu, please
Not
take
really chance.
take instruct. You also please check up whether there was any previous leave to file supplementary affidavit.
There was a previous leave to file supplementary affidavit that is in respect of CAN 4. That was
Have
taken
you
on
given
record.
copies of this to him? You
Yes,
don't-
I've received. I've received.
Very well. Affidavits in opposition and reply filed today be kept on record. Push up on the prayer of learned counsel appearing for the respondent, comma, the matter is adjourned for the day and shall be taken up next on August 25, 2025. Come back.
এগুলো কি জমা দেবো
Supplementary affidavits don't today.
অন্যগুলো
And whatever you have to do, you just check up. If you
একটু তাড়াতাড়ি
can prepare your reply to this, then prepare that and come ready.
দিস না বাদ বাকিগুলো জমা
Next.
Lordship, shall I prepare in respect of the supplementary as well?
Keep it in hand. If it's a short supplementary affidavit, if you allow it, then immediately you
It
can
is that he didn't disclose the income tax lot
point that out.
returns.
Point that out.
That is being disclosed now.
Then there's no scope. We are not directing you to file in opposition. May not be necessary.
I shall prepare because there are certain allegations also in there.
That then. Yes.
I'm for the
Your yes. 10 and 11, two matters. Why two matters?
there are one preferred by one can by the state. My lord, the one section 5, one substitution application.
No, not that. Two separate writ petitions.
That 11, my lord, that is the state.
We have
product
filed one appeal. So you say.
One state, one.
Yes, sir, my lord.
And my lord, so far section 5 is concerned, so state appeal is concerned, it was allowed.
It is within time.
It was allowed, not within time.
Say that. No state application is within time.
Never.
If theirs was allowed, yours should be allowed.
Minimum 3 years, minimum.
Article 14 applies. What is your delay?
348 days, madam.
My lord,
336 days, my
You
lord.
obviously won't oppose.
Substitution application, my lord. 336 days, my lord.
substitution, whatever it may, kindly allow it, my lord. I have but my lord, don't
Not the main matter.
don't make my sub because I have submitted.
No, definitely not.
Yes.
So substitution has to be allowed first because the section 5 is there.
Yes, my lord.
Section 5 is filing this.
Yes, my lord. Have 5.
But I am appearing on behalf of the requiring authority, BSNL.
Yeah, for the recording authority. You also won't oppose, obviously.
Substitution application.
Let us just check up which are the application.
Land
There
acquisition.
are 2 applications, my lord. 1 and 2.
1 and
That's
2, these
allowed,
are in
yeah.
connection with your appeal, which is MAT 187, right?
Yes, my lord. No, 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 no.
Well, let us, my lord, allow it, my lord. Let us come to the, my lord. So far, my appeal is concerned, my lord, I will take just 10 minutes time.
Oh,
Yes, my lord. So far, after that, my lord.
can one of
Can, 10, 11. My lord, my lord, kindly allow that.
we are doing that. We are passing. This is the order.
Oh, yes.
That is substitution.
Can one of 2024 is an application for substitution
করতে হবে তো, তারপরে তো শোনা
Uh,
যাবে।
of the heirs of the sole appellant Sheikh Nasiruddin Ahmed on his demise on April 14, 2023. Full stop. Can 2 of 2024 is an application for condonation of delay in filing Can 1 of 2024. Full stop. Upon perusal, what is the ground taken? Just tell us.
My lord, she was ready. She doesn't know that. Thereafter, one fine morning, she found that her husband has filed an appeal.
Have you abused the advocate, previous advocate, or you are the advocate?
No, no, previous advocate was there. My,
What have you said against him? That is important.
আর এগেনস্টে কিছু বলেননি তো?
No, 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 my lord.
আর এগেনস্টে বলবেন থাকলেও বলবেন
In view of sufficient explanation for the delay having been made out, comma, Can 2 of 2024 is allowed, thereby condoning the delay in preferring Can 1 of 2024. Full stop. Since Can 1 of 2024 is otherwise in form, comma, the same is allowed, thereby directing the heirs and legal representatives of the deceased sole appellant Sheikh Nasiruddin Ahmed as appellants in the present appeal. Full stop. The necessary consequential corrections in the cause title of the memorandum of appeal and the connected pending applications shall be carried out by the learned advocate on record for the appellants during the course of the day. Yes, the main appeal.
Yes,
But, state appeal also be collected.
Yes, my lord.
Cause title of the state
Cause
appeal.
title, yes.
Also, I mean,
Correct.
my lord. But-
Acha, leave is granted to the learned advocate on record for the appellant in MAT 1540 of
Yes.
2018 to carry out the necessary rectifications in the cause title of the memorandum of the said appeal by implementing the names, by incorporating the names of the heirs and legal representatives of Sheikh Nasiruddin Ahmed, who is a party to the said appeal, by tomorrow.
Yes.
By tomorrow, you can do. Thank you for pointing out. Yes.
Well, now, my lord, kindly come to.
State has challenged. This is against what?
This is against, my lord, the order because.
But my lord, today I have not
দাঁড়ান,
No, not prepared.
I'm
Daran, daran, what is daran, daran?
prepared, my lord. I thought
He's
you
not
only said
prepared,
you
the poor man, and you are saying daran, daran.
My lord, kindly come to the last order.
দাঁড়ান না
Everybody is standing, Mr. Shengu. What do you have to say?
my lord, only thing, my lord, I just point out, my lord, these are the thing, my lord, which my lord will go into that. My lord, first of all, my lord, these are the state prefer, why state prefer an appeal? I just put that question to myself because the honorable single judge passed an order
Yes.
allowing their petition directing the state to initiate proceeding and to make compensation under the 2013 Act. That is the new act. My lord, my challenge so far this appeal is concerned, my lord, only basis on the twofold. Admittedly, my lord, the land was acquired long before. My lord, 1988 something. A position was taken under Act 2. My lord, and there, Section 41A of Act 2 was already invoked. And my lord, after that, my lord, kindly consider, after that, the 93B and 93A was introduced in this because 31st March 1997, that Act 2 expires or dies this natural death. So, before that, in the amended provision, in order to carry out the unfinished work,
because 9(3)A and 9(3)B was introduced.
If he's not ready, let us come back on Monday and complete the.
Because
Please come prepared
Monday,
on Monday.
Monday, that's fixed. So that Monday one matter.
So we'll just adjourn it for the day, the main matter. And
Monday, so that we do after that, I think, that will help us.
no, it may not be taken up, but we are keeping it on Monday. In the list, it will appear in the list as it is.
May it appear on Tuesday, my lord? Can it appear? I will not be there on Monday, my lord.
Tuesday,
Tuesday, my lord.
Tuesday, Mr.
I'm grateful.
Let the appeals be listed together for hearing on August 26, 2025, Tuesday.
I'm grateful.
Grateful. You please come prepared on that date. We'll hear.
Yes, ma'am. I will come.
Item number 12, I am for the husband appellant, my lord. This is my application under order 41 rule 27. There is no caveat, my lord, so I have not served yet, my lord.
Toloban and written up notice form you have to put in.
Yes, my lord.
Do that. You have to serve also.
Yes, I have to serve, my lord.
Two applications. Order 41 rule 27.
Order 41 rule 27 is I am pressing because, my lord, the husband and wife celebrated their first marriage anniversary sometime in the year 2016.
This is only the order 41 rule 27 which is
only, my lord.
So we'll direct it to appear along with the hearing of the appeal, usual
my
order.
lord. Yes, my lord.
And in the meantime, affidavits may be exchanged.
Yes,
whenever. But you have to serve copy.
Yes, I will
direct you to serve.
Kindly direct me, I will serve, my lord.
Correct. Can 1 of 2025 is an application in for production of additional evidence under Order 41 Rule 27 of the Code of Civil Procedure. First stop, by the very nature of the application, it is required to be heard along with the hearing of the appeal. Full stop. Accordingly, can 1 of 2025 shall be listed for hearing along with the appeal when the latter is ready for hearing. Full stop. A copy of can 1 of 2025 shall be served by the learned advocate for the appellant on the respondent, indicating that the application shall be listed along with the appeal. Full stop. Affidavits, if any, shall be exchanged in the meantime. The appellant shall put in the requisites and Tolobana, put in the Tolobana, postal cost, written up notice form, and other requisites within a week from date. Full stop. Paperwork directions were given? No.
No, my lord.
Full stop.
That's very short issue. The papers are not much, my lord.
The evidence,
So,
if evidence has been laid,
evidence I have all the certified copies.
we'll direct you to prepare informal paperwork.
Kindly.
But records we cannot dispense with. Let it come. The trial court record shall be brought by special messenger at the cost of the appellant, to be also to be deposited within a week from date. Full stop. Since learned counsel for the appellant submits that the matter, the issues involved are short, and the appellant is posted with all the relevant documents, the appellant shall prepare and file the requisite number of paper books without informal paper books without comparing with the records within 4 weeks from the notice of arrival of the trial court records. You prepare it before that. When it comes, you just check up with the trial court record and file. Liberty to the parties to mention the appeal along with the application for hearing as and when the same is ready for hearing. Yes, so respondent must be here for the appellant. Yes.
Amla Kurvi is against the interim order.
Yes.
Back past 8th is the date fixed by the learned trial judge for hearing of the main matter.
Thank you for making it easy for us. Yes, Mr. Chatterjee. You have recorded all your arguments. 8th is the next day, 8th September.
8th September it has been fixed.
After affidavit, the matter has been fixed.
So we'll not go into the merits, Mr. Chatterjee. We'll direct the.
But what had happened, my lord?
Whatever order we pass may prejudice.
But what had happened at the time of passing of the ad interim order, my lord? After the cancellation of the LOA.
Not may prejudice, shall prejudice.
If your lordship hears me for 2 minutes, my lord. But third party rights were created, my lord. After the letter of acceptance was cancelled, third party rights were created, my lord. At this juncture, my lord,
created third party rights.
Yes, my lord. We have granted letter of acceptance in favor of third parties, my lord.
Their LOA was rejected. They have challenged that in the writ petition, but in the meantime, you have granted it to others.
That was not taken into consideration.
Injunction was granted.
Injunction was
from doing what?
My lord, there were 9 tank trucks which were being inducted.
by the writ petitioner, my lord, offered by the writ petitioner in the tender. Out of that, my lords, the learned single judge has been pleased to direct that 7 of them should continue to run and 2 of them cannot run. And we have already granted letter of acceptance in favor of 9 trucks and third-party rights for being created. So that prejudiced us imaging me so much that we are before your lordship.
But at this stage of the ad interim stage, the court has to go by the averments made in the injunction.
But that was not disclosed.
Since it has been disclosed now, Mr. Chatterjee, is all the same necessary for the trial court to go into those. Whether you have created those rights with knowledge of the, with notice of their intention to pay for the writ petition,
But,
these aspects have to be gone into. Affidavits have already, you have prepared your affidavit in opposition.
Yes, yes.
Everything has been prepared.
Affidavit has been filed before the.
We'll request the trial judge to take it up positively on, in some other fashion.
Very well, ma'am. Kindly record my submission to this extent, my lord, so that.
What is your any answer to that?
I have answered. Because your lordship, if you lordship read the order, on that day, it was hard. On in contested hearing, it was identity order was passed. There, my lord, there is no question of granting any third party. This may have, my lord, done. I am not saying that on oath today.
They had already created, he's saying.
No, that is in backdated.
No, my lord.
Because the nature of the my lord order, which says 9 trucks, 7 clean, nothing. For 2, I am unable to produce the smart card. Smart card as a card, it comes later. Card is with me, all documents with me. Smart card will come by post today. Nowadays.
No, that is on the merits of the.
No, that's what. Those are also ready in so many terms. But the learned trial, honorable single judge, my lord, don't allow me to run those 2. But 7, which is clear. The question is whether for default, if I.
No, after cancelling your, refusing your LOA, if they have created third party rights.
No.
We say you are disputing that.
With respect to my learned friend, my lord, that is not possible these days because everything is done online. There's no physical.
No, why didn't you point out you were appearing there?
But we had prayed for affidavits, my lord, at that juncture.
But did you orally argue that?
But it was not indicated, my lord, in the order. It's not indicated in the order. It's not indicated.
If you appeared, we thought it was expert.
No.
If you appeared and it was not indicated, because you must have not had instruction at that point of time. But even
that is why
there's the fault in the order of the court. But how can the court know if you don't point out? You are the one who has to point out. I mean, you is
that
your
is
client.
the reason at the time of ad interim stage, my lord, we had prayed that maybe bring documents on record by filing of an affidavit. But and that juncture, the interim order was being granted.
We'll record, but we'll not touch the merits, and we'll say all the more a reason for us to leave it to the learned trial. Because now affidavits are there, your reply must be also there.
It is. Everything is ready.
Learned, the present appeal has been preferred against an ad interim order of injunction granted by the learned single judge. For sub next para, learned counsel appearing for the appellant submits that despite the appellant having created third party rights in respect of the subject tank trucks, those are called tank trucks. Tank trucks. Prior to the passing of the order, the learned single judge passed restraint orders in respect of 7 tank trucks. Full stop next para. Learned senior counsel appearing for the respondent opposes such contention and argues that the said objection was not taken before the learned single judge. Full stop next para. To this, learned counsel for the appellant submits that the appellant, precisely for pointing out such facts, sought for directions of affidavit. Full stop be that as it may, since we are apprised that the injunction application is itself fixed for hearing before the learned single judge on September 8, 2025, and affidavits have been exchanged in respect of the same, and the same is otherwise ready for hearing, we are we do not intend to interfere, we do not intend to take up the appeal on merits, since any observation made by the appellate court might prejudice the hearing of the injunction application itself. In any event, since the dispute as raised in the present appeal can only be thrashed out upon affidavits being exchanged, we relegate the matter to be heard before the learned single judge. Accordingly, MAT 769 of 2025 along with the connected application bearing can 1 of 2025 are disposed of without interfering with the impugned order, as well as without entering into the merits of the rival contentions of the parties, comma, requesting the learned single judge to take up the injunction application itself for hearing on the next scheduled date, that is on September 8, 2025. Full stop. Needless to say, comma,
It is civil court always, my lord is thinking of injunction without court.
It's a main writ petition which has been fixed for here.
Acha. Oh yes, sorry.
It happens.
Goes in the system.
Injunction application যেখানে যেখানে বলে গেছি রিট পিটিশন করে দাও, যেখানে যেখানে injunction application রিট পিটিশন করে দাও।
But request we made to the learned single judge to hear on all points, my lord.
No, no, we have made clear that we have
We are
not
not
entered
going
into the
to
merits.
All
আরেকটা লাইন অ্যাড করে দাও, needless to say, comma, all points are kept open to be decided by the learned single judge at the final hearing of the writ petition.
Very good.
No rest to cost.
Very good.
নেই কপালে।
But next matter is my
কপালে
matter.
নেই বোধহয়।
Yes.
No, only because I am for the writ petitioner respondent. State is Mr. Shopon Datta. He has some difficulties today. Can it be taken up on next Tuesday, my lord?
Next item means item?
Next matter. 14.
14, let's say. So you are praying for time. What?
State.
On the prayer of the state, let the matter stand adjourned and be listed next on August 26, 2025, Tuesday.
Oblige, man.
15 Lordship, I am praying for 1 day accommodation. There is some delay, Lordship. In filing, Lordship, we have already filed the Section 5 application before the department, Lordship. Number has not yet been assigned.
So we'll keep it on Tuesday then. Give us the number. On the prayer of the appellant, let the matter stand over till August 26, 2025.
Good.
Well, a big happy on behalf of the appellant in this matter. Lord, I come for a very limited prayer before your lordship.
Yes.
This is a Group 8 matter. Well, the only thing I have come up before your lordship that there was a direction for exchange of affidavits. So on the respective opposition was filed, we were about to submit our reply, but on the respective date we could not appear. But the writ petition was dismissed, considering that we are not willing to submit the affidavit in opposition. Kindly take the order of 25th of March 2025. At this stage, my only humble prayer is kindly remand this matter before the learned single judge so that I can ventilate my cause. Because, my lord, admittedly, we could not appear, my lord. So, this is my only humble prayer before your lordship. এই রিপোর্টটা পেয়েছি আমার রিপোর্টটা
But there is no, this is an inter-court appeal. There is no fault in the order. You did not, you chose not to appear. What could be done?
Yes, my lord, that's on our part, my lord. We were given an opportunity to file an affidavit. We would like to file the affidavit, but before that, this got dismissed, my lord. So
you didn't neither paid for time, nor did
no one appeared, my lord. It is absolutely, my lord. I candidly submit before your
Reflection
lordship.
is there, my lord.
I did not. We could not appear, my lord. My learned friend could not appear.
But difficulty is that you cannot approach that court also because the recall application is not maintainable. This is not a dismissal for default.
Yes. Only, my lord, so that we can participate in the proceeding. That's
Yes, what do you say?
See, my lord pleases to, that is no scope because
no scope of this is there is no error in the order at all.
No error, no error.
Was there any previous default on their part? No, this is the first default.
First
one.
করে দিচ্ছি, একটা chance দিয়ে দিচ্ছি। The scope of the appeal is extremely limited. Full stop. By an order dated March 25, 2025, the learned single judge recorded that despite the petitioner having been liberty to contradict the affidavit filed by the private respondent, no opposition against the affidavit has been placed. Full stop. None appeared for the petitioner to move the writ petition on the relevant date before the learned single judge. Full stop. Accordingly, the learned single judge rendered his observations on merits and disposed of the writ petition. Because of next pair, learned counsel for the appellant submits that due to circumstances beyond the control of the petitioner, the petitioner could not be represented on the relevant date. Full stop. Learned counsel for the states submits that there is no error in the order impugned before this court. Full stop. We are fully aware of our limitations while considering an intra-court appeal. Full stop. To be candid, we do not find any error as such in the impugned order. Full stop. However, keeping in view that the writ petitioner. What do you do by occupation?
Lordship, my occupation.
You are a housewife or something else? Let us see
Housewife.
your affidavit.
Yes. Housewife, yes.
What was the matter relating to?
Some allegations was
The allegation that third party has been given the
Fair price shop. So you are not from marginalized.
No, I applied for it. My lord.
Keeping in view the fact that the absence of the petitioner on March 25, 2025 was the first default of the petitioner before the learned single judge, and keeping in view the fact that the petitioner did not get an opportunity to controvert the stand of the state, we are of the opinion, that although prima facie there is no error in the impugned order, another opportunity ought to be granted to the petitioners to present appellant to place her case before the learned single judge. Full stop. Accordingly, MAT FMA 947 of 2025 is allowed on contest, thereby setting aside the order dated March 25, 2025.
He did not get
And,
an opportunity. He did not choose to appear.
And no, that has been submitted. And remanding the matter to the learned single judge to proceed from the stage where which it had reached by giving a last chance to the petitioner to file her affidavit in connection with the writ petition. Full stop. It is, however, made clear that in the event the petitioner fails to appear on the next date fixed by the learned learned single judge and or file her affidavit on the said date, it will be open to the learned single judge to proceed in accordance with law.
Grateful to Lordship.
Can such and such is can 1 of 2025 is disposed of in the is disposed of accordingly, no orders to cost.
Grateful to Lordship. Much obliged to your Lordship.
Affidavit as is filed to be kept on record. Shankha Pradhame Korone. Affidavit.
Grateful, Your Lordship.
Thank you.
Grateful.
Yes.
Much.
17.
My appeal, my lord. Your lordship had granted us some time to, my lord.
Amicable settlement, not
yes.
reached.
My lord, we were actually asking. It's like Lucknowi style, pehle aap. So they are saying that you give us the proposal. We are saying you give the proposal.
We send both of you to mediation.
But
because there's a mediation drive going on. This
they
is
have said that so, my lord, they want us to give the rent. So, my lord, we are seeking that market rent from the IGR. Subject to what my learned friend says.
And Mr. Bandopad will send you to mediation.
My lord, may I indicate, my lord, if Mr. Bandopad is involved, I think there will not be a problem. Because
No, that we cannot say.
I'm
Cannot
saying
fix it.
formally, my lord, because
Heavy liability on Mr. Bandopad as counsel. No.
my lord, because what has happened is they floated a proposal that we'll pay you the market rent. On 11th, we wrote them a letter, give us your offer, we'll consider it. Now, on 19th, the meeting was also held, my lord. Both the parties sat down together.
So
we said, give us your offer. He said, we have nothing to offer. Well, I understand they are government body, my lord, but what we find, my lord, is that there's actually nothing coming out, my lord, because now
send you to mediation. Let it to go to mediation.
My lord, it will not, my lord. I don't think so.
This can be resolved. The mediator will make you sit on the same table
lord,
and
if it
take
cannot
suggestions from both of you.
My lord, if it cannot happen with Mr. Bandopadhyay, my lord, and me along.
Why it is happening, my lord, friend is absolutely correct. We are government agency, my lord. We cannot say something, even if we like, we cannot give a figure. So we have two ways. Either we get it from the IGR, whatever he says, we forward it. They say, and they have a counter offer, we forward to finance. That is the only difficulty, my lord. We cannot come up with a figure.
No, then yes, you should give a figure, Mr. Khan.
My lord, my figure is I've already given in the supplementary affidavit before the trial court. The bank, in the same premises, bank has taken.
Then you can take it from the IGR.
There in the trial court, my lord.
Yes, my lord. So
everything was given to.
I was suggesting, my lord, kindly post it after a fortnight. In the meantime, we can
let us send it to me, the mediation. Justice Shane will be happy. We will be happy. He's a chairperson of the mediation. He was the previous chairperson of the mediation. He's still the chairperson of the mediation.
Only one thing, my lord, if they can consider the supplementary affidavit, which is already filed, which is there a part of, which is
the
a part
pleadings are before this court. Full stop. Next para, the matter was adjourned previously on the premise that there was a chance of settlement between the parties. Full stop. However, it transpires that the appellant, being government authority, has some procedural difficulties in suggesting a figure for the parties to arrive at a resolution. On the other hand, learned counsel for the respondent number 1 submits that the proposed figure at which the settlement can be arrived at has been disclosed by the said respondent in its supplementary affidavit. We find that since there is no absence of goodwill on the part of both the parties as well as counsel, on the but there is a procedural difficulty in the parties arriving at an amicable solution, we deem the matter to be fit for mediation. So accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of resolutions through mediation.
Only one thing.
Liberty to the parties to mention the matter in the event the mediation fails.
But the supplementary affidavit was filed before the learned single judge, not before your lordship.
We have said the pleadings. Supplementary affidavit একটা কথা বলেছি, হ্যাঁ, যেখানেই supplementary affidavit বলে থাকি, filed before the learned single judge. একটা ইউজ করেছি টার্ম দেখবে একটা জায়গায় supplementary. Respondent number 1 disclose করেছে যে figure has been disclosed in the supplementary affidavit filed before the learned single judge.
Grateful.
The interim order may be extended till.
Interim order is extended.
No, November.
Until further order.
You want to?
My lord, kindly makes a time limit, my lord, because
अच्छा,
otherwise,
interim
my lord,
order is extended till November 30, 2025 or until further order, whichever is earlier.
पूजा आ जाएगा.
180 days.
my lord, because my lord, if lordship will kindly
We will
give a
actively
time frame
participate.
for
I
the
am there, my
mediation.
lord. My learned friend need not worry.
No,
We
no.
will actively participate, my lord. We don't want to be thrown out.
Right.
Grateful.
My lord, I beg to appear on behalf of the appellate in this matter.
For the state, my lord.
My lord, there's a longish order. Before that, I just draw your lordship's attention regarding this matter. My lord, I applied for FPS dealership.
The Dr. you can take your seat.
Yes, we'll
Let
take
us hear
some.
it. Yes.
I applied for FPS dealership. My lord, I was rejected on the ground that the land I offered, it is under the nomenclature of Shodok. It's a nomenclature. So it's not a Vastu land. So I will not be considered for the FPS dealership. My lord, I challenged that. This is a third round of litigation. I challenged that land has already been, the recording has already been corrected by the BLLRO. They have accepted their mistake, that by mistake it has been recorded as Sadak, but it should be a Vastu.
Sar means?
Sadak means Shodok, this road.
Sar, acha.
Yes, Shodok. It is Shodok, so it will not be a Shodok, it will be Vastu land. So on that count, my lord, writ petition was filed. It was considered.
Was there any document from the authorities?
Yes,
the
yes,
BLLR,
everything. That has already been considered by the previous order. The Honorable Single Bench was pleased to direct them to file affidavit to show the inquiry report, which is the most vital document regarding granting of a lordship was already considered in various matters, that inquiry report. That was considered, and his lordship was pleased to find that no, it has wrongly been recorded as Shodok. It should be Vastu. So on that count, your candidature cannot be rejected. Now then the direction was passed upon the authority to consider my application afresh. Now, my lord, they considered and they again rejected me on the ground that on the appropriate date of application, you did not have sufficient balance of 50,000 rupees, which is the requirement as in terms of the notification. So I challenged that before the Honorable Single Bench on the count that this point was all along available to the state authorities to reject. In the inquiry report, it has been mentioned there is no suppression on my part. They have recorded my balance. They said, yes, we are satisfied. Only on the ground of Shodok, I am not allowing you. So at this stage, again, you come with the same process and now you bring a new point saying that you are not allowed because you did not have the balance. That was my whole bone of contention.
This is that second round.
This is second round. Now, my lord, we took shelter of Mohinder Singh's judgment that if you cannot develop a case subsequently on the same process, you cannot bring with another reason to reject my case. That is my case before lordship. Lordship, I draw your lordship's kind attention to the order impugned for once. Page 154 of the application. Dated 14th of July 2025.
Yes, you can refer to the internal pages.
Yes, my lord, my lord. If your lordship kindly takes, it is all recorded.
Internal page.
Memo থেকে দেখা। Yes, my lord, the internal page, all are recorded.
Yes, yes, directions.
My lord, kindly take the operative portion. My judgment was, which I referred, was recorded in page number 6, internal page number 6 at the top. And the
What, Mohinder Singh?
Yes, that has been considered but not allowed in my favor.
But court on the previous occasion had not closed the issue, but had
No,
directed
did not close.
consideration.
Fresh consideration. Yes, absolutely. I bow down to your lordship.
Was the vacancy that notification?
The first notification. Yes.
Whether it was a mandatory.
Yes, it was. My lord, I admit this. It is an admitted position.
Then there is no,
I tell your lordship
error in the
why I have come before your lordship. My lord, kindly come to.
Previous order has also been recorded by the learned single judge in his at page 2.
This was his lordship's order.
So fresh consideration.
Yes. Now, my lord, why I have come before your lordship? Kindly take the inquiry report, which is very vital. Kindly come to page 1.
No, that's sir.
Lordship.
Regarding that, sir, Shodok.
No, regarding my application. This is a whole conclusive inquiry report, page 145. Kindly take page 145. Because every candidate goes through this inquiry process.
Inquiries.
Now, my lord, kindly see page 145. If your lordship kindly takes page 145, your lordship has found.
What is the
Yes.
relevant column?
My lord, kindly come to the 20, clause 20. Whether the applicant is financially solvent as per order number, please mention such and such. The finding is yes. They are referring it to be as yes. They are satisfied with my solvency. Account number such and such. Balance is 52,575 as on 24th of January.
You admit that on that date it was 2 lakhs, 2,000 something.
Yes, I tell you, 29th was the date of application. 24th of January, I had this balance. And 29th, on that date of application, admittedly, it has 2,000 and odd. So, my lord, they had
They've committed an error, they have corrected that.
Possibly not, my lord, subject to correction.
Inquiries for that purpose. Oh, achha, you say the inquiry, up to the inquiry report that has.
Yes, it has been accepted.
But inquiry report by itself does not give you a right. No.
I tell you, lord.
Right is accrued in your favor because they have to consider that inquiry report may be a basis of their consideration. But they can independently consider.
Independent. May I just show two more things, my lord? Now, my lord, kindly come to page number 147 for once. Because this inquiry report considers all aspects, not only one, all aspects. Kindly come to my lord, page 147 for once. Kindly take this. My lord, kindly take 62 serial number.
Yes.
Well, kindly see, overall, it is satisfactory. They were satisfied with my condition. And my lord, kindly take 64, any document not submitted by the applicant, all documents submitted. And 65, overall comments with positive, negative recommendation. The character of land is sadak, the application is not recommended. It was the previous one. Now, they were also aware of my solvency at that point of time. They had accepted it, but they never raised an issue in the previous writ petition that no, he will not be allowed because he did not have that account. Now,
there's no estoppel here because this is not a, what should you say? We cannot hold state to estoppel because there are certain criteria. If they have on inquiry found out that criteria was never met just because they committed an error, and moreover the previous order directed them to consider that it was reopening of the issue.
True. Only one humble submission before lordship, my lord. They only rejected me on one ground, Shodok ground. Now, can they on the same application, they bring the new...
That was the scope of the consideration because this is an inquiry report. This is like a piece of evidence, sort of. Civil court need not be bound by the evidence.
Yes.
Similar principle here also. Inquiry report is one of the major basis, but not the sole basis. They can independently also inquire.
Yes, well, if I go by the Mohinder Singhal judgment, if your lordship kindly considers paragraph 8 for once.
Mohinder Singh is not applicable. It was in the same case. It was not taken before the trial judge, it was taken in the challenge.
I understand.
This is not at the stage of a challenge. You are right. Mohinder Singhal says that you cannot disclose for the first time in a challenge against an order which was not placed before that authority. Let us see this paragraph since you are.
May I just hand over the judgment for once?
Yes.
Paragraph 8.
Right.
Just for once.
Paragraph 8 is quoted.
Quoted in the judgment order itself. Yes.
My lord, kindly take paragraph 8. Why I am placing reliance upon paragraph number 8?
Which paragraph was quoted in?
Paragraph 8. 8
itself.
8 itself.
So you could see from the judge. Why did you
for your
spend so much for this?
No, for your lordship's convenience, my lord.
Thank you.
I just brought this judgment. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by freshly reasons in the shape of affidavit or otherwise.
You are absolutely right, but this entire judgment, this proposition becomes academic in your case because it was reopened by the previous order. If it had not been, then you had a very good case.
Yes, but on oath they...
Now Mr. Datta has a very good case.
I understand, my lord. I can only try before your lordship, my lord. My humble submission before lordship is, it says affidavit or otherwise. Now this otherwise word opens up the scope of my submission. Otherwise, subsequently, you come with a fresh reasoned order and say that no, you did not have that balance. But it is not that I suppressed it. They were aware of it. They allowed it. But now they are coming with a fresh reason. They could have rejected me on the same ground earlier. No. Now, every time a person will come on the new ground, he will be rejected every time if they find. They did not.
If every time we direct them to reopen the issue, and then it will be done.
But my lord kindly appreciates
That's why sometimes we also do it. We say that on this point, on other points. or something like that is there in some certain orders.
Yes, there.
We often do it. I mean, this point we decide this in the light of these findings.
Yes,
it will
yes.
be reconsidered.
Kindly appreciate one
It's
thing.
like a remand.
I submitted on 29th all the bank details of up to 24th. I submitted. It is not that I never had the amount on that date. But
It's not a question of your lack of bona fides. No, they are not saying that.
Yes.
They're saying that you did not meet the statutory the vacancy.
Yes,
That what's
yes.
that called? Vacancy notification.
Notification. Eligibility criteria for vacancy.
Yes, that's called a vacancy notification.
Yes, yes.
Those eligibility was not met by you. So, no.
Subsequently, if they can do it.
This is not a wrong order. Intra-court appeal very difficult to.
I understand, madam.
We are with you,
Yes.
sympathies, but
I understand, madam.
we can express that in our order if you like.
No, madam, that is my humble submission before
The
Lordship.
scope of the present challenge is limited. Mr. Dotto, we have heard you. Yes. The scope of the present, in fact, we have heard you. You pointed out that this paragraph was mentioned in this. The conspectus of the
point, if any, originated at the department level, not after coming to court. That's what paragraph
Yes,
says.
exactly. That we agree with that. Yes. You learn friend also agrees with that, but
Yes,
yes,
he knows that. He knows, but he's trying his best.
the conspectus of the present appeal is limited. Full stop. The petitioner applied for what is that called?
Yes.
What
Madam.
certificate?
This is
Dealership,
madam,
dealership.
FPS vacancy.
FPS,
Page 58. This is the notification. FPS dealership. FPS vacancy notice.
Applied for an FPS dealership. Full stop. Initially, the said application was rejected on the ground that the character of the land was recorded as within double inverted Sorok, SARAK, double inverted close. Full stop. Next para. The petitioner challenged the said rejection on the ground that the recording in respect of the said land was erroneous, which had been revealed from the relevant documents. Full stop. The said previous writ petition, preferred against the prior rejection, was ultimately allowed, thereby directing the appropriate authorities to reconsider the application of the writ petitioner afresh. Full stop. Next para. However, upon such reconsideration, the respondent authorities now rejected the application on the ground that the requisite balance as per the vacancy notification, was not there in the bank account of the petitioner on the date of the application for such a dealership. Push-up learned counsel appearing for the appellant argues that the learned trial judge committed a legal error in dismissing the writ petition in view of the principle as laid down in Mohinder Singh Gill and another versus the Chief Election Commissioner, New Delhi and others, reported at 1978 1 SCC 405. Fusap, it is submitted that once particular reasons are given for rejection by the respondent authorities, such reasons cannot be subsequently supplemented by fresh reasons in the shape of affidavit or otherwise. Full stop. By placing reliance on the expression double inverted or otherwise, double inverted close, learned counsel contends that such resiling from the earlier position and supplementation by a fresh reason is not permitted in any manner whatsoever. Full stop. Next para. It is, thus, argued that the respondent authorities could not have refuted the application of the petitioner on the second round on a fresh ground, by supplementing the original ground of rejection. Push up next para. Learned counsel appearing for the state opposes the arguments of the appellant and contends that paragraph number 8 of Mohinder Singh Gill's case, which was considered and quoted by the learned single judge in the impugned order, categorically recorded that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Full stop. However, it is contended that in the present case, since in the previous round of litigation, The writ court had directed a fresh consideration of the application of the appellant, comma, all issues were kept open to be considered, full stop. Hence, comma, the respondents were justified in rejecting the application of the appellants on a ground as stipulated in the vacancy notification. Full stop. Next para. Upon hearing learned counsel, comma, we find substance in the contention of the respondents. Full stop. Next para. Mohinder Singh Gill's judgment was rendered in a context of a challenge against a state action. Full stop. Where the executive rejects an application or chooses a certain course of action by assigning particular reasons, comma, it cannot improve upon the said reasons, comma, either by way of affidavit or otherwise by supplementing or supplanting fresh reasons at the stage of challenge against its action. Full stop. Next para. However, comma, in the present case, comma, the said proposition is not applicable simply because in the earlier round of litigation, comma, the writ court had not restricted the scope of consideration only to the rejection on the ground of the classification of the land being incorrect, but kept it open for a fresh for the authorities to consider the application afresh on all grounds. Full stop. The said previous order, comma, in fact, comma, was quoted in the impugned judgment by the learned single judge. Full stop. By such previous order, comma, the writ court had directed that the concerned authority shall dispose of the representation of the petitioner and shall issue the license in favor of the petitioner, তারপর double inverted, if she otherwise appears to be suitable according to the provisions of law, double inverted close, full stop. Going by the said direction, comma, the respondent authorities were justified, comma, in accordance with the appropriate provisions of law and the rules enumerated in the vacancy notification, comma, in rejecting the application for FPS dealership of the appellant on a valid and justified ground. Full stop. On facts, comma, there is a controversy that the appellant did not have the requisite amount in her bank account on the date of the application, and as such, comma, we do not find any illegality committed by the learned single judge. Full stop. Accordingly, MAT 1145 of 2025 is dismissed, comma, thereby affirming the judgment and order dated July 14, 2025, passed in WPA 13372 of 2025. Full stop. Can 1 of 2025 is accordingly disposed of as well. No order as to cost.
Grateful to Lordship. Much obliged.
That's great.
প্রথমে একটা affidavit of service file to be kept. You can keep it, Mr. You can use it in some.
Yes, that's what I will advise.
Yes, exactly.
You take it back. 100 pages judgment.
Only
Paragraph 8
may be
is always
necessary.
cited. Only paragraph 8.
Yes.
In many matters.
Yes.
Right.
Grateful to Lordship.
Thank
Much
you. Next. Yes, Mr. Go.
My lord, certain documents have been supplied to me, my lord. I shall rely upon those documents, my lord. But before it, if your lordship may kindly permit me, then I will like to place the case in list of dates of the case, my lord. That is though annexed with the memo of appeal, but not with this application. That's why, my lord, I prepared separate list of dates.
Thank you. Yes, Mr. Agol.
My lord, a vacancy for location near Manuchak, Jaipai Primary School for appointment of a FPS dealer was published by SCF. It is admitted fact, my lord. I am not. Page 35 of this these documents will show that I have made an application in statutory form. No, my lord. I entered into a notarized agreement with the landlord. That is at page 35 of this document, my lord.
Of this bunch of documents you give?
Bunch of documents.
Achha.
And there it has been mentioned as plot number 387.
All right.
And relying upon this document, I have made an application mentioning the plot number 387 in my application. Now the area inspector, my lord, inquired into my application. He has seen the godown, measured the godown. He has seen the boundaries of the godown. This is similar boundary which is in the inquiry report, which is in this document. Then, my lord, the lease deed was subsequently registered as per at the behest of the licensing authority that you will have to execute the lease deed. That was registered lease deed in respect of that same 387. Then, my lord, I was granted license. The respondent subsequently, my lord, it came to the knowledge by a document, by a notice that is issued at page, my lord, 6 May, page 39 of my application, and it should be here also.
Mr. Agarwal, can you give a copy of the list of deed to them?
Yes, I have given.
I have received. Page 39 of the application.
39 of my application.
Yes. Notice, yes.
Yeah. This was the notice intimating. Well, may I read it out here?
Yes, yes, please.
An allegation has come to the notice of the undersigned. My lord will mark that some allegation has come. That FPS godown is physically situated on plot number 375, Khatian number such and such, but it appears from information and supporting documents submitted by yourself during filling up application form against vacancy notice such and such, the godown is situated on plot number 387, Khatian number 7. Same Khatian number, but a plot number different. And accordingly, the said FPS license was issued in favor of yourself on 12 February 2025. As such, it is crystal clear that you have willfully conducted, willfully conducted fraudulent dealing with the government office. Fraud has been alleged, my lord.
Yes.
Upon a complaint, it is prejudice in the mind of the authority that I have committed a fraud by mentioning this. And since they have got an allegation from someone.
But Mr. Agarwal, if they don't disclose the allegation against you, then you would say that the show cause notice does not.
No, my lord, I'm not.
So either way, either they prejudice.
I am on this, that allegation was not, the allegation which they have received, no document has been supplied to me.
The suo motu also they can reopen if they find that.
They may reopen.
Bar, yes.
They may reopen, but upon.
But since they say an allegation has come to the notice.
So allegation should be supplied to me.
All right.
No document has been supplied. That is my case, my lord.
All right.
Hence, you are directed to appear before the undersigned on 13 May 2025 at office chamber situated at such and such. I had appeared, my lord. And my lord, there is a hearing sheet I have got in this document, which was not supplied to me at the time of hearing. That is at page 13.
Of
documents. Page 13
of this. Achha.
But this was not supplied to me. That's why this has come now here.
1313.
13.
Achha.
My lord, there are the questions.
How did you get this? They have given this to you?
They have given this today. Otherwise,
otherwise this will be another fraud. You will be hauled up for that, your client.
My lord, আপনার নাম ঠিকানা, I have given that. Number 2, আপনি কোন ব্লকের FPS dealer, দোকান নাম্বার কত, that's you given my license number and this.
Yes, yes.
3, আপনি কিভাবে এই FPS লাইসেন্স পেলেন? 4, এই FPS লাইসেন্স পাওয়ার জন্য যে গোডাউন দেখিয়েছেন আর আমুল কোথায়, আর আমুল কোথায়, আর অবস্থান কোথায়? I am sorry, but I am.
No, you're good. Your Bengali is much better than Mr. Dhor's Hindi, probably. So you have to compare balance of convenience. So 387 has been scored to 4 is important.
387. Then after I said
your signature is
375.
So you disclose 375.
375.
You are honest before the officer.
Before the officer, because that allegation was there, then I came to know that yes, it was a correct allegation. Then my lord, FPS was the abedan
rester
করেছেন.
Are they important? Rest.
Rest, my lord. Yes, madam. I have said
next 5 is important because your application says 387.
6 is important, my lord.
Acha. Yes.
আপনার অতিরিক্ত কোনো বক্তব্য থাকলে বলুন। গোডাউনের পরিবর্তনে দাগ নম্বর সংক্রান্ত তথ্যটি আমরা
আমার
আমরা
ছিল।
অজ্ঞাত ছিলাম।
Right, right.
আমার অজ্ঞাত ছিল, অজ্ঞাত কারণে বস্তু আমি সমাপ্ত।
So you admit everything and you say that, so you say it's not a fraud, deliberately suppressing or
This
something.
was a mistake.
Mistake.
And mistake can be rectified at any stage. Your lordship knows better than me, my lord. Right. So,
But you obtained the dealership on the basis of that. That is it. But they should also have inquired. They must have inquired.
they have made inquiry.
Their inquiry report must be
Inquiry
there.
report is there. They have disclosed the inquiry report.
What is the inquiry report? Let us see what is there.
Page 38 of their page 38 of their documents.
38, yes. Of these documents?
Yes, these documents.
Where is the relevant? Is there any?
That is, go down. My lord, page 41.
Yes.
Dag number 387, Khatiyan number such and such. They have inspected it and they have admitted
This is their report. Huh?
This is their report. No, my lord, they were also not aware that this is 375. They have also admitted that this is 387.
So two things. One is that their report also says 387. So they committed the same mistake. And secondly, in the inquiry, you have directly replied that yes, it was a mistake. And
your lordship might know, my lord knows better than when there is a judgment.
Yes.
That if the boundary disclosed a plot and a plot number is different or there is no plot number has been mentioned,
yes,
then that plot will have to be recognized as a value. Well, this is judgment.
But how is that applicable? Here the plot number was different.
Plot number are different. Identical issue, my lord.
Achha, let us see.
What has happened in this case, that a degree was given in a sale certificate, my lord.
Sale certificate was given.
And in that sale certificate, one plot was mentioned, another plot was not mentioned. But the boundary was given. Then the court held that when the boundary is given, then both the plots are supposed to be.
Your boundary was correct in this case. Achha, where is the boundary? Where do you found?
Yes, lease deed. Your lordship will kindly come to lease deed. That is also in this document.
You had submitted the lease deed itself, in fact.
Yes, I have also submitted and they have also given.
So the lease deed Toposhil is at page 27.
Hello, I say just now.
That's the
Yes,
schedule.
27.
Yes.
This is the same boundary, madam.
387 it says.
Yes.
But
Only
then another
plot-
problem arises. Then where is the proof of your having any title in respect of 375?
See, I am not the owner.
Lease, but the lease is in respect of different plot.
The same owner has got the. I will show that.
But this lease deed was never rectified.
That is, my lord, under.
So insofar as 375 is concerned, Mr. Agarwal, apart from the fraud, you don't have any right on 375 then.
No, that is. I have.
They will do it later on.
They will do. They have applied for rectification
Of the lease deed.
Lease deed, my lord.
But in this matter, I appear for the respondent number 5, my lord.
Yes.
The landlord, the owner of the land.
You agree with him.
Yes, my lord.
There was a mistake.
There was a mistake. The boundary of the plot where the godown is situated is the correct, but the plot number has been mistakenly given.
Boundary in the deed, in the lease deed is correct.
Yes.
That defines 375.
No, lease deed also is 387. So that lease deed.
No, not that. Mr. Agarwal, we are saying that the boundaries given in the lease deed,
that is correct.
they circumscribe 375. But the number has been given erroneously as 387.
That is erroneously given, my lord. At the time of preparing the lease deed, that was erroneously typed.
Was it a registered lease deed?
Yes, my lord.
So you are willing to rectify that also?
I am willing
Can
to
we record
rectify.
the submission?
Yes.
Now let us hear Mr. Dhar. No, your judgment first. Sorry.
Only thing that due to the pendency of this matter, nothing can be done in the meantime.
No, we understand. But your willingness is all we are ascertaining.
7, na?
Any particular paragraph, Mr. Agarwal?
Para 7, my lord. Para 7. Big paragraph, my lord. 5, 6, 7. My lord, the page 255 at the bottom.
We are
We
there.
find
Yes.
considerable substance in this contention. The position in law is well settled that certificate of sale are documents of title which ought not to be lightly regarded or loosely construed. Well, then after this is
Yes, yes.
The matter may have been different if no boundaries had been given in
Yes,
the
Mr. Agarwal, we have seen it. Yes.
Not
So this is all.
Honorable,
Acha, one is, what is, yes.
that is the final order. That is at page 41 of my petition.
Yes. Let us see that. Is there any provision under which they can cancel the license if there is fraud?
No, my lord, there is no provision.
No provision of law as such.
What they have submitted is 45(3). Your lordship can find 41. At the last that they have invoked the power under 45(3). And I have submitted to your lordship, my lord, that 45(3).
Oh, that for that reason you handed over the control order.
Yes, my lord. 45(3).
Let us see 45.
It is admitted in the order that it is inadvertently recorded.
These premises. No, guilty of the contravention. Which provision applies? 45(3)?
45, he has said, my lord.
Acting in such manner which is prejudicial to the interests of the beneficiaries does not apply.
No.
Hamper smooth implementation does not apply. If found guilty of any of the contravention mentioned in these orders.
That is not. That does not apply.
So then what will apply? But it cannot be that if you obtain a license by fraud, they cannot cancel. That cannot be the position of law.
My lord, let us take in that way. If I commit a fraud, then though no section is required, let us assume for the time being.
No, then no. But if there is any specific provision, Mr. Agarwal, if it stipulates that it has to be fraud, and you have not committed fraud, so we have quoted 45(3) only.
That is not there. That is not there.
45(3) is not applicable.
And my lord, moreover, your lordship knows, my lord, fraud merely by chanting that it is a fraud, that there can be error. They have accepted inadvertent error. Inadvertent error.
Inadvertent error, and which is also
recorded in the order.
And your landlord also agrees. First, secondly, boundaries are there. So let us hear, Mr.
My lord.
Dhar. Yes.
Kindly come to, my lord, the bunch, my lord.
Yes.
And kindly come to last page, 57. It starts from page 54. This is the terms and conditions through which we invite the applications.
Yes.
Now, my lord, kindly come to at page 57.
Yes.
What are the terms and conditions? Kindly come to Roman 4. Any suppression of fact.
Yes.
Or information or incorporation providing of wrong information in the application form or attached documents will be considered as a good and justifiable reason for disqualification for a candidate or rejection of application and taking appropriate legal action. Then 5, the licensing authority or government department reserves the right to reject any application such and such. Here we have allowed them, we have allowed
hearing
their application. Then we got to know about these anomalies, and they do not, the particular writ petitioner does not have any agreement with the landlord in respect of where he has or where she is showing that she does have the go down.
You are satisfied. Your inquiry report is satisfied.
As per their declaration. That's they have.
It's your inquiry report.
On the basis
inquiry,
of the,
what is the use of an inquiry if it's on the basis of if their application is treated to be sacrosanct?
If I
that is the purpose of inquiry, to ascertain whether they are correct or not.
I bow down. If 387 is there and 375 is there, and she does have the lease deed on 387, and there is an existence of go down on 387, but the nomenclature of 375 has not been changed from agriculture to Vastu. So I won't be able to give them the license on that plot.
You have not stated that in your order.
First, she has to have the document to possess the land. Then construction, then nature and character has to be also to be changed. Otherwise, her application won't be entertained. She is not eligible. How can I improve that?
When you inquired, you must have inquired into the with
On
the
the
boundary.
on the basis of the declaration made, and we were told, we were identified, oh, this is
You won't ascertain from the records whether that's the correct plot or not. In this way, you give licenses.
I am not the revenue authority. Here I am the FPS licensing authority.
Yes.
That information I do not have.
But your license is given on certain yardsticks. What is the purpose of your inquiry? It's an eyewash then. Then all inquiries will become suspect tomorrow.
To some extent, we need to rely on the person who is applying. Taking
What is the meaning of inquiry? What is the use of an inquiry? Or an investigation or an inspection even? Inquiry is on a higher footing. You inquire something.
Yes.
Inquiry, implicit in that is a question. You are questioning that. Query from query. You are inquiring.
On that,
even an inspection, what is the purpose of an inspection? You go and have some tea. If the tea is not good to your taste, then you reject the application like this.
On that score, my lord, every inquiry has to be done along with the revenue officer's help.
They give you a deed. You take the deed and go there. How do you ascertain whether the land is that land? Without doing that, you give a license. And an FPS dealership.
On the basis of the identification made by the...
Then you are bound by that. How can you do that? What is the source of your information now?
Now, my lord, kindly come.
And boundaries are same, Mr. Thor. The identity of the property is not in dispute.
Difficulty is the nomenclature. Nature and character has to
Nature and character is the same, because if the boundary is that, because you say that you go by their deed. If you go by their deed, you went by the boundaries, what is there, and that nomenclature, that character of that land is that, whatever they have disclosed. Whatever the lease has been granted in respect of a particular land, right?
Well,
this land. Now, this is called, instead of a rose, it is called a chrysanthemum, so that it's difficult for you to spell it. So, but ultimately, these boundaries are shown. This rose does not become the rose does not become a chrysanthemum. If they state it to be a chrysanthemum, boundary remains, the identity remains. You have identified that plot with the boundaries, and you say you are satisfied with the recording. Now, what about this recording? This land, because if it's 375, Mr. Dhar has a point there. 387 you have stated. 387, they might have checked the records and saw that 387 is a whatever, the character passed through. But who knows what is there in 375?
375 is JOL, according to the records. That application has been made for conversion after this.
Then at the time of the application or the inquiry, it was not converted. Then you are not eligible otherwise also.
My lord, if that, no, my lord, there is a, your lordship will find at page 37, we have got the sanction for construction on the land. That is page 37.
No, lease deed says there is a building, go down there.
Yes, there is a go down, and that sanction has been given by the Haldia Development Authority at page 37, 38.
All right. So in the lease deed, the plot, the go down is actually there.
Yes, madam.
But the conversion you have applied later on.
Yes. Two things had to be corrected. One, conversion, and one in plot number in the lease deed. And those both are curable defect, madam.
But they say as plot number 375 is classified as JAL.
Yes,
what is the rule on that, on there? Let us see that vacancy notification again. The character of the land, what is that a curable defect? Let us see.
No, that they say that there's three.
Show us the relevant provision.
Last page, my lord.
Then you have rejected on two grounds, both grounds.
No. No.
Go down already, everything is there. You saw that go down also. There's
Yes, madam, that is page 56. Roman 7 B. page 57, Roman 7, capital B, then small b. If record of right is not produced, then my lord,
Yes, yes. But here you produce this document.
yes, and that is your lordship has
Yes, previous matter.
the 3 months I can do it. That is curable defect. And particularly when sanction has been accorded by the competent authority for construction on that land.
Yes, that has been given.
Yes. Page 38.
Sanction you have produced.
Yes, that is at page 38.
But you're producing by way of this bunch. Did you produce before them? Oh, at 38. That's it.
Yes,
38 is that
subsequent.
that inquiry report.
Office of
No, 38 is 38 of what? Your application?
my application.
Sanction plan was there.
When plan was submitted to the Haldia Development Authority, Haldia Development Authority has given the sanction. This is the post sanction, madam.
Post getting the license.
Madam,
After
yes.
getting the license.
Post getting the license, madam. Yes, yes, post getting. In advertence, when
All are
all
post facto, my lord. We are not allowed to, my lord, on the date of application.
But this is not a ground on which you can reject the application even.
Kindly come to their page 38 of the
Application.
Of the writ petition, one, perhaps. Yes. Kindly come to the page 38. That was the record of rights shown on the day. 375 is showing Jol and 387 is showing Bastu. So no conversion, nothing was done on the date of application. So we could not have even entertained her application.
Why do you say that? Which provision in the vacancy?
Kindly come to page 38. That is the record of rights. They rely.
No, which provision in the vacancy notification permits you to do that?
Kindly
Because
come.
the document you have to give, either they have to give this registered deed.
Kindly come to page 56 of that bunch.
Yes, yes, we are there.
And then kindly come to documents related with go down and shop office, Roman 7.
Yes.
In case of ownership or shared ownership.
Not applicable.
Then B, a document showing character. Then in case of property owned by
B is actually in case of property owned by a family member.
Yes, B.
B should also not be applicable.
Then for
C
lease,
should apply.
C. Rent property, then registered as a name and layout map dimensions in case of applicant is other than illegal.
Registered stroke notarized lease deed or tenancy agreement for at least such and such years. This much. They need not even produce a record of right. Worse than that. Your rules. Certificate of medical fitness of the individual has to be given. Now you'll reject on that ground. She couldn't run 100 miles in suppose 10 seconds. Or some possible thing like that. You plant these Easter eggs in your applications and then you find out those and tax these people.
No,
if your fees are higher than the advocate's fees, they go for you, otherwise go for the advocate, otherwise they go to you. What is this, Mr. This is a bona fide mistake. Landlord comes and says, yes, we agree, boundaries are correct. The construction go down was there, that was the requirement as per your vacancy.
For not having an appropriate classification also.
Under which provision?
For rejection.
Has to be there in the somewhere. Control order does not contain anything such.
Control order I have given. Control order নেই কোনো জায়গায় না নতুনটা না দিয়েছি নতুনটা দিয়েছি
You cannot find out new grounds in court. Mohinder Singh Gill cited in the previous one. Your ground is only that they have practiced fraud. You have stated two grounds actually.
Yes.
Fraud on two counts. One is that number of the plot wrong and character is Jol. But we find that you physically found a go down, we find the lease deed, landlord comes and says boundaries agree that boundaries are the same. So there is actually a go down there. They have a post facto sanction plan there. Sanction plan is not a requirement in your this vacancy notification.
That I agree. But the classification must be on the date of.
Where do you get that? Classification, there is nothing about classification.
For others, I can see there is a.
Classification, yes.
In case of ownership,
If
kindly
they were
come to B. Document showing character of land as Dukan commercial Bastu. If record of rights is not produced.
Character is only applicable to owners.
Then Malad kindly come to.
সেটা তো ওনারদের ক্ষেত্রে ওনার আর
বি
এটা
document
অ্যাপ্লাই
showing
করছে না,
character
ওনার
of
নয়।
again
সিটা শুধু ফর লিজ rented properties শুধু অ্যাপ্লাই করছে। আর these are the only requirements.
Yesterday also, my lord, I was stuck in this point. That if the lease deed is there, I can't say that it is Zola was.
Yes.
Lease deed itself is a complete document.
We are trying to find out, you are trying to find out, Mr. Agarwal, nobody is finding any provision, and it must not be there.
Control order.
They must have a ready go down.
Yes.
You went and found a ready go down, that was the requirement. What did the learned single judge hold?
Well, there he took a point that no show cause was given to him.
Well, kindly see the last line.
Apart from that, we have seen everything.
Well, the last, but the
Yes.
para 18 I have shown your lordship. This
Well, kindly come to the impugned order at page 44.
No, give the
Roman
internal page,
six.
Mr. Give the internal page. Internal page.
Internal page 2.
Yes.
6. Kindly come to para 5, 6. That was the case made out. And 7. Only violation of natural justice. Since order was passed quoting subsection 3 of section 45.
But the court was looking at something which is fraud. You had to establish fraud.
There is the judgment I am not saying to your lordship, my lord. That fraud has to be established beyond doubt. Justice
Yes.
Kumar
on the
given
first
a judgment on this.
But you did not take the ground. These grounds were not taken specifically by the learned single.
Learned single judge, my lord, kindly see last.
Not even in the writ petition it has been pleaded.
Yes, that has been pleaded.
This petition, many things are there, but you don't.
Not been submitted.
No, my lord. Kindly see, I have got the copy of the writ petition.
So writ petition, it may be there. We are not. Might not have submitted.
Clause 45.
But there are findings of the learned single judge going into the merits of your rejection also. Which para 13 onwards.
4 points have been formulated.
See, first of all, 45.3 is not applicable here. 45.3 was not.
That, Malad, I
generally, if
wanted
there is fraud,
Malad, I wanted to show one judgment. Malad, down matter. Malad, where there is a down it.
New impanelment.
No, Malad,
Old
actually, my
impanelment.
learned junior could not come today, Malad, because of. There were a. It down. Initially, Malad, that
you don't
was
have a copy.
Down. Issue was, Malad,
to rectify orders arising out of procedural defects was inherent in a tribunal.
Yes. Well, under Society Registration Act, well, the authority initially granted on the basis of the declaration.
It's a 31 not a tribunal.
Well, I'm not saying, well, kindly, well, here the society registrar had issued a society registration on the basis of the application made. Subsequently, society registrar got to know that fraud has been done on him. Then he decided to revoke that registration.
They're not saying you don't have power. You relied on 45(3), that has been considered by the court.
Kindly, I say, kindly do
Even
not
apart
go
from
by,
45(3),
do not go by
very well.
nomenclature.
Mr. Agarwal at the outset said fairly enough that yes, although 45(3) does not provide, if there is a fraud actually, then you can do
Inherent.
it.
It's inherent.
Let us proceed on that premise. You are right. If someone practices fraud, the authority issuing the license has the implicit power, inherent power to recall that also.
Yes.
But then fraud has to be established. 45(3) is on a different count. You rely on 45(3). You have no, it's a wrong, not a wrong caption. You invoke power under 45(3). 45(3) is something else. You have not established 45(3). Then you have to establish fraud. Now, where is the fraud? They admit, they come, boundaries tally, your inquiry report is against you. No,
but on the basis of wrong classification, how could I?
Wrong classification is not a ground. I mean, even for refusal, we don't find that. That is what we are asking repeatedly from you.
And even a single in a matter,
yes,
the one of the single matter, my lord, it was held that this cannot be a ground for rejection of that JAL.
No, because there are different scopes of consideration by different authorities. Like suppose an authority recording your possession does not have the power to. That's why we say that the records of right do not prove title. Why? The premise is that those recording authorities do not have the power to decide your title. So there's a limit up to what they can go into, what they can see. So therefore, you have your eligibility criteria. One is he has to have a go down, and if he has a lease, he has to show the lease agreement. He showed a lease agreement, boundaries are correct, number is wrong, landlord is saying that's a correct number, wrongly mentioned.
If he does have tenancy agreement or lease agreement clubbed with other documents, but does not have the proper classification of the land, land is still showing agricultural land.
You cannot haul him up because your rules do not provide that. The land revenue authorities may do it definitely. If they have converted a land without a valid permission to convert, one.
Their force is there.
Secondly, yes, but you do not classify anywhere. You are, in fact, if it's a family member, your yardstick is document showing character of land as Dukan, commercial bastu, if records of right not produced. So, family members have an option not to produce the record of right, produce only this document showing character as bastu, and then get the license. If the family members can do that, why can't a lessee? Because we have to look into the other provisions. None of these provisions permit you to do that, even in case of family members. Even for owners, same. Even owners can go scot-free by showing a title document, but nothing else.
If ROR is not produced,
they will not produce. Somebody does not produce ROR and produces only the deed. That is sufficient as per your regulations. That is what we are saying. So people can do that. If they can do that as per your rules, then the character of the land is not vital. If it was an essential criterion, that is what we are trying to impress upon you. If character of the land was essential, then they had to prove record of right.
If it is not produced means
they don't produce the record of right,
which is not available
nowhere there. It's an optional thing. In case of shared ownership, prior to that, applicant must submit the following copies. What? In case of ownership also, A, photocopy of record of right. B, categorically says document showing character of land such and such if records of right is not produced, not available. They can do that. If they can do that, then character is not. Character is no longer important. It is an obsolete concept now. So we'll allow this. The present appeal এটা হবে একটু মনে and judgment from size of এটা তো appeal judgment from হ্যাঁ ঠিক আছে oh no the appeal and the application are taken up for hearing together in view of the identity of the issues raised in both. First up, the appeal has been preferred against an order of the learned single judge whereby the writ petition has been dismissed. First up, in the writ petition, the appellant had challenged the rejection of the FPS dealership of the appellant on the ground that the appellant had committed fraud. First up, although initially, before the writ court, primarily a ground was taken that no show cause notice was served prior to passing such order, learned counsel appearing for the appellant submits that although a notice was given, the ground of fraud was not established. First up, learned counsel argues that in the present case, the FPS license was obtained upon an inquiry report having been taken by the respondent authorities in accordance with law and only after verification of the veracity of the application of the appellant, was the license granted. Push up next para, learned counsel submits that two grounds have been cited in the order cancelling the license of the present appellant. Push up the first ground was that the wrong plot number was mentioned in the lease deed which was produced by the appellant and which plot was reiterated in the application by the appellant to be the land where the godown in question stood. First up, learned counsel submits that the recording in the lease deed of the number of the plot as 387 was entirely a bona fide error, whereas the correct number should have been plot number 375. First up, it is submitted that since the boundaries of the plot tally with that of plot number 375 and are correctly disclosed in the lease deed, there could not be any dispute about the identity of the plot. First up, that apart, even the inquiry report of the respondent authorities indicates that the authorities proceeded on the premise that the godown which was inspected, was standing on plot number 387. First up, thus, the stand of the appellant that it was a bona fide mistake and not a deliberate suppression is vindicated since the authorities themselves also committed the same error in their inquiry report. Push up next para, learned counsel places reliance on a judgment in the matter of such and such reported at 1995 3 SCC 252, where the Supreme Court observed that the position in law is well settled that certificates of sale are documents of title which ought not to be lightly regarded or loosely construed. Push up next para, the Supreme Court went on to observe by relying on previous judgments that in the sales certificate, the boundaries as well as the plot number were mentioned, but there was a mistake in mentioning the plot number, in which context it was held that the matter may have been different if no boundaries had been given in the final decree for sale as well as in the sale certificate and only the plot number was mentioned. First up, but where both the boundaries and the plot numbers were given and there was a mistake in the plot number, it must be treated to be a mere misdescription which does not affect the identity of the property sold. Full stop. Next para, insofar as the other ground cited for cancellation of the appellant's license is concerned, learned counsel for the appellant argues that although the character of plot number 375 was recorded as within double inverted JAL, JAL, double enclosed, that is water body, comma, in reality, comma, the lease deed describes the godown situated on the said property, comma, which was also established from the inquiry report of the respondent authorities themselves. Full stop. Thus, comma, the mere erroneous recording in the records of right cannot alter the fate of the license issued to the appellant, comma, since the required criterion was that a godown in appropriate proportions as indicated in the uh, vacancy notification were to be satisfied. Full stop. Next para. Learned counsel appearing, you are for respondent number 5.
Respondent 5.
Learned counsel for respondent number 5, comma, who is the landlord of the appellant, comma, appears through counsel and submits that the appellant that the erroneous description in the lease deed was a mere mistake on the part of both parties, that is the appellant and the respondent number 5, and supports the stand of the appellant to the effect that the same was merely a bona fide mistake, whereas the boundaries given in the lease deed identify plot number 375 and not plot number 387, and the number of the plot given in the lease deed was a misnomer. Full stop. Next para. Learned counsel appearing for the state opposes the contention of the appellant and submits that the appellant did not raise the issues raised before this court before the learned single judge, and the primary ground taken was non-service of a prior show cause notice. Full stop. Next para. It is further submitted, comma, by placing reliance on a division, a coordinate bench judgment of this court, Namta Diye, reported at 2019 1 CHN Cal 533. Which paragraph did you rely on, Mr. Hort?
There was conflict between two judges. Then it was referred before Justice Datta, and Justice Datta has relied by saying that proposition is this is inherent power.
Comma, where there was a conflict of views between the honorable judges, first of the matter was referred to a larger bench, to a learned third judge of this court, which is also cited before this court. First of the learned single judge, comma, while resolving the conflict, comma, held that even if there was no provision, no specific provision for review of a decision on the ground of fraud, comma, the same was inherent in a tribunal stroke authority. Full stop. Next para, it is submitted that as such, comma, even if the grounds as stated in Rule 45 within bracket 3 of the control order of 2024 were not satisfied, comma, the respondent authorities had the inherent power to cancel a license in the capacity of the license issuing authority if there was a fraud or suppression deliberately practiced by the applicant. Full stop. Next para. Moreover, comma, it is submitted that the relevant plot, that is plot number 375, comma, where the godown of the appellant is actually situated, comma, is still classified as JOL, and as such, comma, the license could not have been issued in the first place. Full stop. As soon as the fraud was detected, comma, it is submitted, comma, the license was duly cancelled. Full stop. Next para. Upon a perusal of the impugned order of the learned single judge, comma, we find that the learned single judge was not restricted in his inquiry to the grounds raised by the appellant stroke writ petitioner, but also entered into the question as to whether fraud was practiced by the appellant, comma, thus opening the entire gamut of the issues raised by the parties before this court. Full stop, next para. The first ground which is required to be considered is whether the respondents had power under clause 45 within bracket 3 of the TPDS Control Order 2024 to cancel the license on the grounds as cited in the reasoned order dated August 1, 2025, comma, since it is the said provision which was cited specifically and invoked in the said order cancelling the license. Full stop. Rule 45, clause 45 within bracket 3 contemplates a situation where the licensing authority, comma, on a complaint received against a dealer or suo motu, comma, is prima facie satisfied that the dealer is acting in such a manner which is prejudicial to the interest of the beneficiaries tagged with his fair price shop, or may hamper smooth implementation of public distribution, or may lead to law and order situation, comma, in which case, comma, the licensing authority may immediately render the license under suspension, and after giving the dealer an opportunity of being heard, comma, if found guilty of any of the contravention mentioned in the control orders, comma, may, for reasons to be recorded in writing, impose punishment of either fine or reduction of the volume of business according to the gravity of the offense, or termination of the license. Full stop, next para. In the present case, comma, there is no allegation in the nature of those envisaged under clause 45 within bracket 3. Full stop, next para. However, comma, this court is aware of the position of law, comma, in terms of the judgment rendered by the learned single judge within bracket third judge in Liang, Liang, Miao, Miao, Sheng, Sheng, comma, that an authority has inherent power, comma, if it is the authority issuing the license, comma, also to terminate the license in the event a palpable fraud is practiced on it while obtaining the license. Full stop, next para. If such a power is not read into the authority of the license issuing entity, comma, it would create havoc, comma, since a person practicing fraud while obtaining the license could never then be hauled up for such gross contravention of principles of natural justice and the basic tenets of Indian law. Full stop, next para. However, comma, we are unable to convince ourselves from the materials on record that in the present case, comma, a deliberate fraud was practiced by the appellant. Full stop. Next para, to constitute within double inverted fraud, double inverted clause, comma, there has to be an element of deliberate and willful action on the part of the concerned person. Full stop. Unless the action is deliberate, comma, either in commission or omission, comma, it cannot be said that a fraud has been perpetrated by the concerned person. Full stop. There are several mitigating circumstances in the present case in favor of the appellant. Full stop. First, comma, the boundaries of the premises, which was the subject matter of the lease deed produced by the appellant, clearly demarcate plot number 375 as it has come out from the submissions of parties, comma, although it was wrongly numbered as plot number 387 in the lease deed. Full stop. Pursuant to the ratio laid down in P. Udayani Devi's case, comma, in such a situation, comma, it will be deemed that the description of the plot number was a misdescription, was a mere misdescription, and does not vitiate the transaction as such. Full stop. Borrowing the said principle in the circumstances of the present case, comma, we find that the erroneous description of the plot number in the lease deed was a bona fide error and not a deliberate suppression. Full stop. Since otherwise the boundaries tally with plot number 375, comma, and the landlord appears before this court and categorically supports the contention of the appellant that it was a mistake in enumerating plot number 387 instead of 375, comma, we are of the opinion that no case of fraud has been made out. Full stop. Next para, even otherwise, comma, on the second ground of rejection, comma, we do not find from the vacancy notification any ground on which the character misdescription of the character of the land would be germane. Full stop. Next para, while perusing the said, which was the page number of the vacancy notification? It was in the bunch of papers.
Yes, 57. Starts from 54.
Right.
In that bunch of documents.
Thank you.
57.
In the vacancy notification, comma, clause 10 describes the supporting documents which an applicant has to file along with the application. Full stop. Next para, clause capital C within bracket is the relevant provision which is applicable in the present case, comma, since it deals with leased, LEASED, stroke rented property. Full stop. The requirement under the said head is for the applicant to file to submit a registered stroke notarized lease deed or tenancy agreement for at least 4 years with copies of rent receipts for all the months from the date of agreement. Full stop. Next para, we do not find from subhead C, comma, pertaining to let out leased properties, comma, that the records of right have to be produced at all. Full stop. Next para, even otherwise, comma, clause capital A within bracket, which deals with ownership properties, comma, the requirement under subclause small a, jeta big A, small a within bracket, is the production of the photocopy of records of rights, stroke registered deed of conveyance, comma, etc. Full stop. However, comma, such requirement is diluted by the immediately succeeding clause small b, subclause small b, which provides that a document showing the character of land as dokan within single inverted dokan stroke commercial stroke bastu single inverted close would be sufficient if records of rights are not produced. Full stop. It is conspicuous that the language used is not records of rights double inverted mode are not available double inverted close, but double inverted is not produced double inverted close, comma, thereby leaving the option entirely on the applicant either to produce the records of rights or any document showing the character of land as dokan stroke commercial stroke bastu. Full stop. Next para, even in case of a property owned by a family member of the applicant, comma, covered by clause capital B within bracket, comma, the requirement is similar to that of an owned property, Full stop. Hence, comma, from a composite reading of all the provisions of clause A, clause 10 of the vacancy notification, comma, we find that the production of the records of right is entirely optional, and if any document is produced showing the nature and character of the land, comma, that would suffice for getting a license. Full stop. Rather, comma, in the case of a leased out property, even there is no requirement even to produce the extracts of the record of right as an option. Full stop. The only document required is a registered stroke notarized lease deed, which may describe the character of the property. Full stop. Next para. Hence, comma, it is evident from the vacancy notification itself that the character of the land need not be established by production of the records of right. Full stop. If such requirement is not an essential requirement of the vacancy notification itself, comma, which circumscribes the grant of the license, comma, non-production of such document or non-disclosure of such fact would be entirely irrelevant while cancelling the license as well. Full stop. A requirement which is not there for issuance of a license cannot be a ground for cancelling the license. Full stop. Next para. Hence, comma, the description of the property of plot number 375 as JAL in the records of right is not germane and not a valid basis for cancellation of a license at all. Full stop. In any event, comma, the appellant submits through counsel that an application has already been made for effecting the necessary rectification in the records of rights, and that a conversion application has since been made as well. Full stop. Be that as it may, comma, since those are not essential criteria under the vacancy notification, comma, we are of the opinion that the cancellation of the license of the appellant was entirely misdirected and based on grounds not validated by the extant rules and regulations of the respondent authorities themselves. Full stop. Hence, comma, with utmost respect, comma, the learned single judge proceeded on erroneous yardsticks in affirming the cancellation of the license of the appellant and dismissing the writ petition. Full stop. Accordingly, what was the prayer in your writ petition?
My lord, writ petition. But
You must have sought for cancellation, setting aside that order, rescind order.
Yes, yes.
Acha. Accordingly, MAT 1300 of 2025 is allowed on contest, thereby setting aside the impugned judgment and order dated August 5, 2025, passed in WPS 17891 of 2025, as well as setting aside the order, the rescind order, double inverted with the rescind order, whereby the license, FPS license of the appellant was cancelled, comma, bearing memo number 348 stroke capse SCH stroke capse MR, তারপর admin, এটা শুধু capital, MR admin stroke 25 dated August 1, 2025, and restoring the FPS license of the appellant. Full stop.
My lord, the tagging order is also there.
What order?
Subsequent order, my lord. Consequential order, my lord.
Any action, any consequential action taken?
Well, that is at page 42 of state petition.
Acha, the consequential order dated August 1, 2025, comma, bearing memo number 260 stroke INSP stroke capse F commercial and S stroke N-I stroke 25 of event date is also set aside. Full stop. Any action taken pursuant to the impugned orders, comma, which have been set aside above, comma, are also stand automatically revoked and cancelled. Full stop. Next para. Can 1 of 2025 is.
My lord, will kindly want to let the license be restored. Otherwise, my lord.
We have said that.
But
license, yes. The license of the appellant is revived. Revived na restored ki bolon? Restored boleche.
Restored, my lord.
Thereby restoring the license. That's the first line of order. Acha. Can 1 of 2025 is consequentially disposed of as well? No address to cost.
Deeply obliged.
Only one prayer on this, only one submission on behalf of the respondent 5, that the respondent 5 is willing to execute a necessary instrument to rectify the plot number.
That you have not recorded in your order because that is not necessary for, because if we have proceeded on the. আচ্ছা ঠিক আছে একটা বোল্ড লেটারে তলা লিখে দাও উইল যেখানে রেসপন্ডেন্ট নাম্বার 5 এর ইয়েগুলো রেকর্ড করেছি ওখানটা হ্যাঁ সাবমিশনটা Learned counsel for the respondent number 5 stroke landlord further submits that the landlord is agreeable to rectify the lease deed by executing an appropriate registered document by incorporating plot number 375 instead of plot number 387 in favor of the appellant. This is added to that. Thank you.
My lord, the books your lordship can keep because
No.
My lord, that is the control order. You will not find in the.
No, we'll lose it from here. Keep it with you. We'll ask whoever
We
comes.
have got also, my lord. That is for
Then
your.
we'll keep one set. Thank you very much, Mr. Ahol.
My lord, because
this happened to us in the electricity determination. The CSC lady, the officer,
Yes.
she handed over that copy. We are ever grateful to her for that. and we'll ever be grateful for you.
No, not my,
to
my,
you for this.
we will be grateful because we will not have to give again and again.
আচ্ছা এইটা না এইটা বইয়ের মতো একটা
And
হ্যাঁ
I've
বইয়ের
given
মতো
two sets for two.
মোটেই থাকবে আমার কাছে চলে না থ্যাংক ইউ নেক্সট
Smile.
Yes.
My lord, your lordship has been pleased to hear it sometime yesterday.
Thank you. Yes, yes.
My lord, may I continue with your lordship's permission?
Yes, yes, absolutely. Please.
My lord, on the last occasion, my learned friend, my lord, had placed the two inquiry reports. Which are at pages 29 and 41 of the affidavit in opposition of the stay application, my lord. My lord, only for recapitulation, my lord.
Yes.
The short point, my lord, if I may, point is not short, but if I in a short manner, my lord, if I may say, my lord. My lord, in this matter, in an earlier round, the principal secretary was directed to consider the grievance of the writ petitioner. The matter was sent to the principal secretary because the petitioner's application was rejected and the license was to be sought to be given to the private respondent. Now, the principal secretary, upon consideration, said that there should be a re-inquiry of the entire matter, and I will pass an order upon that re-inquiry being made. That earlier order of this order of the principal secretary is not under challenge before your lordship. Now, my lord, a re-inquiry is held, and based on the re-inquiry's report, the principal secretary passes an order.
Oh, the dimensions of the
dimensions have changed, and my lord, it was not completed, etc.
That matter which he was arguing.
Yes, what Mr. Singh was arguing, my lord.
Yes.
Now, principal secretary passes an order.
Yes.
And in the meantime, the license is also granted to the private respondent, because in our humble submission, when the matter was relegated to the principal secretary, there was no stay on the entire proceeding. In fact, the honorable judge allowed us to proceed specifically in that order. The point taken by Mr. Sarkar in this appearing for the appellant was that it is, if I have understood correctly, my lord, that it's a post-decisional hearing which has been given to them. And since the principal secretary had already given the license and thereafter the decision came, and therefore it's a post-decisional hearing, number one. And number two, my learned senior has also tried to import a lot of, my lord, the principles of disciplinary proceedings which are attributable to a public service, my lord, into this arena, which is basically a field with regard to appointment and what right an applicant has in a recruitment process. And I will ultimately argue that all the principles and preponderance of probability as entailed with a disciplinary proceeding are not applicable in this case.
We are expecting that argument because we put the question to Mr. Sarkar also. These relate to disciplinary proceedings.
Yes, my lord, even if it
we'll
is
hear Mr. Sarkar on that also in reply.
Even if we take a bit of in a concentrated form what we get from those and put it in a quasi-judicial proceeding, etc., then also, my lord, it will be very tough to incorporate all the provisions, because, my lord, ultimately natural justice cannot be, my lord, stretched to a point where the entire in-house proceeding, that is my recruitment process, becomes absolutely unworkable, and time and again a matter is sent back to me, I hear, then someone say I was not heard, inquiry report not given to me. So it has to be judged on the parameter that what right the applicant had. He is not a government employee.
Yes.
Who is governed by a particular set of service rules. He has not attained that vested right as yet. Though, my lord, on that parameter, my lord, my action has to be tested.
His rights were on the threshold because he had not been.
My lord, today he is an applicant.
Right.
In a process. So, therefore, the parameter should be whether I was fair or not. He cannot demand. It is not a question of whether I have violated natural justice. Question is whether he can today come and complain of a stringent process of compliance of natural justice where my in-house proceeding will become unworkable. In fact, my lord, without knowing the petitioner at all, long time back, Lord Denning has said that these points are taken by those whose matter is very unscrupulous. I'll show that.
See every day.
But not necessarily always. I'll show that line, my lord.
What happened, Mr. Bandyopadhyay, before the Puja vacation, previously Puja bonus was being given in our times. Now, what happened subsequently, the good matters which went, we were very tensed. When those matter came up for hearing, those were kept under the category of Puja bonus and there is nothing in a matter. But some were very good matters. So all cannot be labeled, painted in the same.
Correct.
But you are right that these points may be taken by people who are, I mean, otherwise.
Yes, Malad, rather Malad, not having points on merit.
Yes.
No, Malad, on that pretext, Malad, Mr. Singh had placed the two inquiry reports, Malad. I'll only place it subsequently later, Malad, if required.
Yes.
Now, Malad, if your lordship kindly now comes to the Malad, after the inquiries, Malad, the inquiries were held on 29th of May 24 as far as the petitioner is concerned, and 3rd of June 2024 as far as the private respondent is concerned.
Yes.
On 21st of June 2024, the petitioner gives a representation before us. But
please give the date again.
21st of June 2024. But I would have, in a other matter, I would not have read these representations. But in this case, it is required because there is an allegation that during inquiry, certain blank documents were made to be signed by the petitioner, which are today, according to them, have gone against them. So contemporaneously, kindly take the representation of 21st June 2024 at page 60 of the affidavit in opposition.
Just 20 days.
Absolutely, my lord. On the heels of the inquiry, they are writing to us.
Yes. Page
60 of the affidavit in opposition of the stay application. I'm sorry.
Yes, page 60.
Pursuant to the vacancy notification caption above, I uploaded my application online on 28th of May 2024 with all relevant documents, which is Aadhaar card, voter, residential certificate, admit card, PAN card, graduation mark sheet, porcha, tax receipt of the land where the godown and the office were constructed by way of plan sanctioned by the competent authority, and the financial capacity affidavit, etc., and the inquiry in respect of thereof was held on 20th May 2024 by the area inspector of Shantipur. Upon inquiry, I came to know that one Minmoy Patro, son of so-and-so, who is not a local resident, has made an application against the said vacancy in question and has influenced the local office to give report in his favor. And for this purpose, he has transferred his name in the voters list of Krishnanagar Kotwali within Krishnanagar subdivision to the voter list of Koromchapuli Shantipur within the Ranaghat subdivision, though all other family members of the Minmoy Patro are still resident of Krishnanagar PS Kotwali, which would be evident from the electoral roll of the Krishnanagar subdivision since enclosed herewith. Moreover, the said Mrinmoy Patro has purchased a land in March 2024 and constructed the godown and office without conversion of land and also without sanction plan from the competent authority to get the subject dealership. The mandatory condition of application is that the applicant should be permanent resident of Ranaghat subdivision, but since the said Mrinmoy Patro was a resident of Krishnanagar subdivision, he has got his name deleted in the voter list of Krishnanagar subdivision and has included his name in the voters list of Ranaghat subdivision. So pausing here for a moment, the question and answer is there in the paragraph itself. The Gram Pradhan, who is very well aware of such fact, has also lodged a complaint in this regard, so and so. In the above premises, since the state government may take up the control over the engagement of the dealership at any stage of processing of the application and to cause inquiry in exigency of public interest, you are requested to take up the matter and, considering the exigency of public interest, direct for an inquiry by the officials of the headquarters so that truth is revealed and an eligible candidate is awarded with the subject dealership, and any applicant who does not deserve to be appointed is not appointed due to his influence upon the local officers. The inquiry is conducted on 29th May. They give this representative 21st June. Still, this afterthought has not come that he was made to sign some blank documents. No complaint in the entire document, my lord. Now, my lord kindly takes the second representation, which is at page 62 of the stay application.
Yes, that blue-eyed representative.
Yes, blue-eyed candidate. But, my lord, what is also relevant is that
yes,
kindly takes yes, action, please. Kindly take the 1 to 4th paragraph.
Yes.
It is placed on record that at the time of inquiry by the area inspector, my godown was in the process of completion, and the said fact would be evident from the videograph of the said inspection. However, the godown was completed in all respect as per EGP criteria within a week thereafter. Therefore, the admitted fact is that as on the date of application, his godown was incomplete, meaning at the date of application also, his godown was incomplete at least. Therefore, he cannot today break any bones with regard to my finding whether his application was, his godown was complete or incomplete. Because ultimately, I am going to argue, since he has harped so much on natural justice, that what prejudice it would have caused to him. After this admission, my lord, I will ultimately argue that no prejudice can be caused to him for all this nitty-gritty, this inquiry report, etc., etc. When he's admitting that he's himself admitting that the go down at least was not there. If it is not there at the time of inspection, it was not there time of application also, which is prior in time. DLFP টা কেন দেখাবো কি আছে জানতে পারছিল যে পাবে না তাই জন্য ঠিক আছে now my lord kindly takes thereafter my lord the order at page 68, which is the earlier round of litigation. There, my lord, first time the allegation of getting signed some blank documents, etc., appears, which is recorded at page 68. Kindly turns over to page 69.
Yes.
Third last paragraph.
Right.
Under the above observation, the writ petition is disposed of. The respondent number 2 is directed to consider the representation of the petitioner being annexure P8 to the writ petition and shall pass a reasoned order after hearing the parties within 8 weeks from the date of passing of this order. The decision shall be intimated to the petitioner made within 2 weeks thereafter. I make it clear that this court has not entered into the merits of the allegation of the present petitioner. The respondent number 2 shall pass a reasoned decision without being influenced by any order of this court and without being influenced by any later decision of the state authority for new appointment of in respect of the same location. Therefore, it was made clear that I can proceed if any later decision is taken by the state government to clear any doubt that this order entails a stay of the entire proceeding. So, my lord, I was not wrong in carrying on with my process. Now, my lord, kindly takes the next page, which is the order passed by the principal secretary after hearing the parties.
Yes.
My lord, may I read a bit of the factual background also, my lord? Yes. Kindly, my lord, takes from 70 bottom, page 70, last line onwards. The background of the instant writ petition in a nutshell is as follows. The subdivisional controller food and supplies published a notification on so-and-so declaring a vacancy for appointment of FPS dealer for the location of Koromchapur. Page 71. 71.
70 bottom, he started from 70 last line.
70 last line থেকে start করেছি.
Now we are in the second or third line of 71.
Then second paragraph of 71. Pursuant to the said notification, the petitioner, since having a godown measuring 442 square feet and office room measuring 216 square feet with shed of public queue measuring 101 square feet, uploaded application in prescribed form along with requisite documents and the application on 14th April 24. It is relevant to mention here the respondent number 8 purchased the land classified as Bashbagan on 21st March 2024 only to apply for dealership against the vacancy in question and constructed godown at the advertised location by illegally cutting down the trees therefrom, and that too without any sanction plan. Then kindly skips over one paragraph. The SCFS inquired into the petitioner's application on 28th May 2024 through the area inspector food and supply Shantipur, when the said area inspector took measurement of the petitioner's shop room and office room and also took photographs thereof and verified the documents with original and obtained the signature of the petitioner on some papers without giving any opportunity to the petitioner to go through the same. Now, these are the points recorded. Kindly turns over to the next page, 72. Then, last, kindly comes to the bottom of page 72.
Yes.
Hence, the instant hearing. Accordingly, a hearing was held on 21st of November 24 at 4 p.m. at the official chamber of the undersigned. The petitioner is represented by so-and-so, Mr. Agarwal was there himself. The petitioner, namely Gauri Das Bishal, is also present. The joint director, so-and-so of the so-and-so were also present. The learned advocate for and on behalf of the petitioner has started his pleading by contending that the subdivisional controller food and supplies Ranaghat, Nodia, public notification. Again, Malad, same reiteration of those facts. Kindly turns over to Malad, 74. First paragraph.
Yes.
The SCFS Ranaghat had submitted that license has not yet been issued. The name of the private respondent Minmoy Patro has been recommended by the SCFS also by the DLFP-SSC, and the case is now lying with the office of the DDPS, Government of West Bengal. The SCFS Ranaghat has further submitted that there are some grounds on the basis of which the petitioner case was not recommended. Number one, minimum required plinth height is 2 feet, but the petitioner's godown plinth is 1 feet. Minimum size of the godown specification is 300 square feet, but the petitioner's godown is measured at 260 square feet. Yes. No shade was there in the petitioner's godown. And number four, at the time of inquiry, as per the report of the inspector, the godown was incomplete. The learned advocate for and on behalf of the petitioner further submitted that the petitioner's godown is measured about 370 square feet and no cement plaster was done only on one side of the wall of the godown, but the godown was very much completed at the time of inspection and has prayed for re-inquiry by the team of the state headquarters. Considering the above facts and circumstances, and after hearing the matter in compliance of the solemn order and judgment of the Honorable High Court dated so and so, the undersigned is of the opinion that a team from the headquarters is to be formed for inquiring into the matter. Thereby, the deputy director, namely so and so, is hereby directed to cause an inquiry. But what is the scope of inquiry? Kindly now sees into the grievances raised by the petitioner. In this instant case, meaning all the grievances,
Remeasured the size was entirely extra. I mean, this was not even that created the problem.
but not restricted thereto. But if I understood the transcript of the
Obviously, if there's a
argument of
new inspection, Mr. Bandyopadhyay, they would get an opportunity to rectify it, whatever they did. Because we cannot it's like violation of a status quo. If today I hold an inspection, how can I know what was the situation then? So this created more problem. Their grievance was limited. Ranaghat votarly strongly named, and the other was that that completion of something like that.
Of the godown.
No, blank paper signature. So there was no necessity for the principal secretary even to direct a new.
The reason was because they said in the preceding paragraph that my godown was so and so in the measurement, but obviously it means that in the inquiry report,
yes,
it was shown to be less.
But remeasure creates the difficulty. No?
But it is not restricted to remeasurement.
No.
It is the entire grievance, because the case being set up by my learned senior on the other side is that the object of the re-inquiry was only remeasurement. Why did you go into all other aspects? You should not have gone into any other aspect. So that is the purpose for me to show that it was all the grievances of the petitioner as well as remeasurement.
That was the direction of the High Court also.
Yes, only to restrict it to the representation. Yes. Well, I bow down to that observation. But also, then Malad kindly, I would complete it. In the instance, and remeasure the size of the godown and also of the recommended candidate, and to submit a report before the undersigned within 10 days from the date of receipt of the order. After receiving the said report from the inquiry officer, the final order will be passed upon considering the inquiry report. So no further hearing. Hearing has been taken as per the Honorable Court's order in this 21st November. In the last paragraph, it has been said that only a re-inquiry will be held on so-and-so campus. This is the broad outline of the re-inquiry. I will take the report and pass the final order. This order, though they were having the knowledge of this order, Malad, at the cost of repetition, was not under challenge in any proceeding. Therefore, this last part of this order, they have accepted that after the inquiry, I will pass my final order. Today, they cannot go behind this order and say, why again an hearing was not given to me? Now, my lord, if they deny knowledge of this order only for the sake of your lordship's convenience,
they appeared.
They appear. No,
order
they
was
may
passed.
say order was not passed.
Yes.
Paragraph 16 of the writ petition is verbatim language of this order. And my lord, it has also been served. I don't want to introduce any new document in appeal, but I am having that
This order was annexed in your opposition.
This order is, my lord, I am reading from the opposition. Yes. Stay application.
Then they had.
They may say that I did not know it contemporaneously. Because it was there in our opposition. We had produced it before the Honorable Single Judge with the copy to them.
Oh, yes, yes, that point was taken by Mr. Sarkar.
But it has been served. I've taken instruction. It has been served upon.
They say, Mr. Sarkar said that those documents were handed over at the hearing. And there was no opportunity for them to controvert, but the learned friend said no.
No,
They did not ask for any
in
opportunity.
the writ petition, kindly takes paragraph 16 and kindly keeps both side by side.
This order was handed over to us after the court order was passed, this hearing was taken. And this order was passed, that was handed over by the principal secretary to us. So we were not opposing this. This order was passed.
Not given to you.
Given to us.
Given to us. So there is no dispute. The order was given to them. So, Malad, they had the knowledge of this order. They did not challenge this order. And the order said that I will, re-inquiry will be held by so and so. I will see the inquiry report, pass an order. It did not contemplate any further hearing.
All right.
Now, Malad, kindly take the inquiry report, for which, Malad, kindly take the opposition, page 53. But this is the inquiry pursuant to the principal secretary's order.
Yes.
53, second paragraph. The date of the inspection was informed to the petitioner Gauridas Vishwas and the recommended candidate upon receipt. The proposed godown of Gauridas Vishwas was inquired for remeasurement on 11th of December 24. The remeasurement of the godown as shown was measured and the details of the measurement is included in a separate sheet. Rough sketch match is as follows. The proposed godown consists of two chambers which are divided by a partial partition wall. The size of the proposed godown is 371. The proposed office sales counter measured as so and so. The office is adjacent to godown or both so and so, two aluminum sheet. I am rather embarrassed to take your lordship through so much of facts. Malad, it is really not Malad.
No, whatever is necessary.
For a 226 jurisdiction, Malad, it is my understanding that it is so much of fact. Malad, I should not invite your lordship with so much of fact. But kindly, Malad,
you can place the relevant portions.
Yes,
that
Malad, kindly takes 55 bottom.
Yes, this.
Considering the vacancy notification, following disparities are noticed against Gauridas Vishwas. Possession of land is not established. The ROR is in the name of Bachu Das, husband of Srimati Gauridas Vishwas. At the time of submission of the application against FPS vacancy, no rent tenancy agreement was uploaded in the portal. An unregistered rent or tenancy agreement was uploaded by the concerned inspector as additional. A notarized rent or tenancy agreement was provided on 11th of December 24, executed between Bachu Das and Gauridas Vishwas for 99 years, executed on 10th June 2024. The layout map uploaded in the portal by Gauridas Vishwas and by inspector is different from the one submitted during the remeasurement on 11th of December 2024, which suggests that modification has been made in the layout plan. It appears from the layout plan and physical observation that the portion shown as office in the first inspection of May 2024 has been shown as godown during the inspection on December 2024. And the portion shown as shed in the layout plan during the first inspection in May 24 and inspection dated December 24 are different. Then number 3, from the uploaded GPS tagged pictures dated May 24, it appears that the godown was incomplete. The present physical observation suggests that modification in construction of godown and office sales counter has been carried out since first inspection. The plinth height of the proposed godown in the GPS tagged picture on 29th May 24 appears to be around 1 feet, and the GPS tagged photos also suggest that the entrance to the proposed godown on May 24 and December 24 are different. On account of the above mentioned ground, the candidature of Gauridas Vishwas appears to be ineligible. Considering the vacancy notification, following disparity is noted against Mrinmoy Patra, that is the private respondent. The classification of land at the time of submission of application of FPS vacancy on 22nd May 24 was Bashbagan, and it appears that no application for conversion was submitted before the date of submission of application for the FPS vacancy, contrary to the memo dated so and so. On account of the above mentioned ground, the disparity Mrinmoy Patra regarding conversion of land may be condoned in comparison to the disparities found in case of Gauridas Vishwas if deemed fit by the authority. Then, Malad, it is placed before the authority and the final order is passed by the principal secretary, which is again at page 78 of the stay application.
And they also pointed out about the marks being 0, and Mr. Singh said that No, marks has to be 0 because if it's incomplete, it's provided in the vacancy
Yes,
notification.
Malad, it is contemplated in 8 Roman
Yes,
4.
yes. He
Brother
relied
dear.
on that.
8-4C.
8-4C.
And
yes.
Mr. Bhattacharya was also there on the last question. He also
8-5C, yes.
was helpful.
Yes. 8-5 page?
Page 47.
Page 47. Can you take page 47? There is the vacancy notification.
Yes. Right.
8-5C. However, if any wall or floor or ceiling roof is incomplete, 8-5C, your lordship got it, Malad?
Yes,
Towards the
yes.
middle?
Yes.
If the godown will be treated as incomplete and the application will not be further processed, it will be marked as incomplete godown in the portal and size and picture as on the date of inspection will be uploaded. However, no marks would be allotted against such applicant and he will be treated as ineligible. No marks means 0, Malad. Final order পরের point final order পরের point
আগে আমরা 22 তারিখে এ দিচ্ছি because there was no stay. Offer letter is admitted. Final order দিয়েছি 24 তারিখ.
point. Now, Malad, kindly take Malad page 78, the final order. I will not read it, Malad, because it is more or less relying on the inquiry report itself. Point 1 to 3, and then Malad 1 point for the Mrinmoy Patra. Then Malad has found these 3 points, Malad.
No.
At 78.
Yes, yes. Same thing. Same as the report actually.
Yes, same.
Obviously, the report, that was the premise on which it was adjourned.
Yes, to see the report.
To see the report and pass on, yes.
Now, Malad, these points are also can be related to the first inquiry. Your lordship pleases, Malad, I can give those pages also. That these are what has been held by the principal secretary today relates also back to the observations made during the first inspection.
Yes, because the GPS were considered.
Yes, because all these points were considered in the first inspection also.
Yes.
But the pretext of sending it back was some grievances were there and the principal secretary had to look into those grievances.
Yes, yes. He compared with the GPS tagging of the earlier occasion and
as far as point number 3 here is concerned, Malad, it is an admitted fact in any event that it was not complete.
In the second representation.
Yes, so the only consideration that remains is that whether
blank signature.
There was any blank signature, Malad, that is an afterthought. Because for that I showed the 21st June. When on 21st June they made a representation, they never spoke about a blank papers.
Contemporary.
No, but that point came up for the first time in the earlier round of writ petition when the matter was relegated.
Second representation.
They made another representation subsequently and made that representation the basis of the earlier round writ petition, by which the matter was relegated to the principal secretary.
Yes, you were saying something.
Yes. So, Malad, what remains, Malad, if Malad, if point number 3 that my godown was not complete is admitted by them in the first representation which I placed, therefore, Malad, what remains is that as far as the private respondent is concerned, whether he could give me an ROR. Malad, land having the character of Bashbagan or not. That is the only question that remains. Malad, to that, Malad, I will invite your lordship's attention to the form which is to be filed, the application which is to be filed. Malad,
you are a lessee or a owner?
Malad, private respondent was a
private. Sorry, you, not you. Private
owner, and they gave me a lease deed.
So that B which we considered in the
conveyance deed.
In the earlier matter, we were.
Yes, Malad, I have in my judgments list, I have just added one judgment, MAT 1300, a judgment and order dated 21st of August, but I cannot.
You are the architect of your doom.
That is why we were laughing that he has argued.
That was very sharp of them, actually.
My 1 point has gone.
Well, immediately we took out the list, took the MAT number, and we made a note.
Yes,
but I cannot place that order, Malad. It is so fresh, but I cannot call it an order because the lordship has not signed it as yet.
No, right. Yes.
Amendment of
29th September.
Although you have taken down all your points, both sides points, we have comprehensive notes, but still will a bullet point short notes will be helpful. Mr. Agarwal and Mr. Bandhavani,
Lord.
because
I shall be giving my lord.
we have comprehensive notes, but
No, but we shall.
so that we don't miss out. Let it not be a new arguments.
No, no, no.
Bullet points, soft bullets, but
Whatever
bullets.
argument has been done, that will be.
Thank you.
Malad, this is a vacancy notification of 1st of September 2023.
This was cited on the. Can you give a photocopy of this later on with your written notes?
Yes.
Just give the first page or whatever is there.
29th of September.
Malad, this was amended on 29th of September 2023. This vacancy is of 1st of September 2023. Therefore,
Sir, Agarwal handed over an amended copy.
Yes, amendment that.
But the amendment was not applicable on that day.
That is their case. So that's why you are asking.
September, when the vacancy notification came, this is the form which was applicable.
It was
now, in point number 32, it says Vastu, commercial, agriculture, etc.
Yes.
So there was actually no debarment for them to give a classification which is beyond Malad, Vastu, commercial or agriculture.
All right.
It was not restricted to Vastu, commercial and agriculture.
Etc. is there.
Because the etc. is there. So, Malad, it is really not a, at the face of it, when the principal secretary's order is taken, it may seem that he is choosing a lesser evil. But actually it is not so. The form permitted him to take it. So what he condoned was not required to be condoned, actually.
Yes.
Number one. Number two, your lordship has held, Malad, now, in the last matter,
yes,
that, Malad, if I have taken down the language correctly, Malad, your lordship has held that character of land is not an essential condition. And the ROR is not required if a document is produced. Therefore, Malad, what he has condoned was not required to be condoned at all. The petitioner will fail on the three discrepancies which is mentioned in the first part of the order itself. We are not required to go into the eligibility or ineligibility of Minmoy Patra at all.
And your first point remains that if they are ineligible, then cannot open this.
Cannot open. I'll place two decisions on that as well, Malad.
The standard decisions. Tender matter decisions.
Tender is there, Malad. FPS is, I brought one FPS also. FPS also I brought.
এটা কি দেখাবে আগের রাউন্ডে ওরা একটা প্রেয়ার করেছিল প্রহিবিশন, ওটা তো ফ্যাক্ট থেকে তুমি
না দেখিয়ে দিয়েছে তো ওটা
লাইসেন্সটা ইস্যু হয়েছে পরে।
Yes, Malad, one fact I need to point out before Lachu, Malad. Malad, this as far as the private respondent is concerned, the date of giving the license to him was, Malad.
Mr. Bandhavani, give us half a second. Hey, Dipankar, এটা একটা তোমার ফোনে ছবি তুলে রাখো তো, এটা কভার পাবে।
Yes. Well, as far as the private respondent is concerned, though there was, but this point has been taken, so I am having to deal with it.
Yes.
Though there was no bar in the earlier round of writ petition to continue with the process, Malad.
Yes.
Malad, this offer letter to the private respondent was given.
Yes, that point was specifically taken by
Yes, on 22nd of January 2025.
Yes.
So there was no bar upon me to give it. So, Malad, that action cannot be held to be wrong.
That was a question put by us because there was no stay. But Mr. Sarkar says the fairness of it.
At all. So, Malad, it was supposed to continue.
Whether it was unfair or not, that is what Mr. Sarkar.
Malad, if that be so,
Justice, fair play, state.
On 22nd February 2025, what was given to the private respondent was an offer letter only, not the license. Malad, after this impugned order, which is before your lordship, Malad, that was passed on 11th of February 2025. The license was actually given to the private respondent on 12th of February 2025 after the dismissal of the writ petition by the Honorable Single Judge.
But before the consideration, after the dismissal of the writ petition, this
license was given. What was given prior to that was an offer letter.
That process of granting license was not completed till then.
Yes, the license granting was one day after the dismissal of the writ petition.
put that in your written notes also.
Yes, my lord, but that is, my lord, we have annexed it at page 50.
No, just just
Yes,
that
I'll
date,
indicate the
because to combat that point.
Yes,
Yes.
Now, my lord, what rights they had? But the rights of a unsuccessful applicant in a FPS process. But if your logic kindly takes 2024 SCC Online Calcutta 3787. 2024 SCC Online Calcutta 3787. This is Shonai Food Marketing versus Bipottayani. Again, my learned friend, Mr. Agarwal, had appeared. He was there for the appellant. Para 8,
Yes.
Actually, in FPS matters, either Mr. Agarwal
Yes,
is
yes,
there,
we understand that.
or Mr. Shara is there, or both are there.
Oh, acha.
So, it is very difficult to find a judgment.
Well, I have shelled out some matters and he should not have said so.
We know how less matters you have. So from our practice days. So don't elaborate on that. Less said the better. Or rather, more said the better.
But we the younger ones are benefited by this plethora of orders that we get
Yes,
to read.
on a particular subject, you get to have a full body of judgments.
Yes. 8.
8,
In
yes.
present case, applications of all 9 applicants, including the present applicants, were rejected. In the earlier petition, the respondent state had filed affidavit in opposition on 24th of March 2021, revealing that the application of the writ petitioner, respondent number 1, had been rejected along with the application of the other applicants on the ground of ineligibility. The writ petitioner in the instant writ petition also did not challenge the rejection of its application. No positive case has been made out by the writ petitioner to show that it is otherwise eligible for consideration of the grant of license of the MR distributorship. The entire case has been made out on the premise that the ground of rejection of the application was not communicated to the writ petitioner respondent number 1, and the appellant in the writ petition is not otherwise eligible. Then Ritesh Tiwari so and so is quoted. Kindly turn to 9.8. Huh? Sorry.
Next page.
9.8.2
next page.
8.2. Yes, next page 8.2.
Yes.
Public distribution system in West Bengal. This is a quotation from Ritesh Tiwari.
Right.
The public distribution system in West Bengal are covered under the 2 Controller of 2013. It is a lifeline of supply chain so far as the distribution of ration items to weaker sections of the society is concerned. In such a case, it is not advisable for the court to prolong the matter sitting in litigation filed frivolously. Taking into consideration the necessity, we held in more than one cases that if a petitioner is not otherwise eligible for engagement as an MR distributor, if he or she has failed to plead grounds showing his or her eligibility with supporting documents, such writ petition should be nipped from the bar. On the question of locus standi, so-and-so, Prashun Sundar Tarafdar, consideration of the above judgment indicates that a common underlying refrain of the decisions of the Supreme Court is that the legal right conferred by a statute or otherwise of a person who has to be violated to confer locus standi on the said person to prefer an application under Article 220 of the Constitution. Unless there is an infringement of legal right, locus standi does not accrue to a person to seek the implementation of a statutory duty by a public authority. Further, in paragraph so and so, Honorable Single Judge has discussed elaborately so and so. The discussion is lucid and self-explanatory, and it needs no further clarification by us. But for the sake of more understanding, we feel persuaded to say here that the petitioner of a particular case has to satisfy the court that he has a legal right to insist on corresponding performance of duty by statutory authorities, and the injury or grievance offered by the petitioner must be affectation of right which should be direct and personal and not psychological and imaginary. From the aforesaid discussion of this court in Prashun Sundar Tarafdar, Supra and the other decisions relied on by us, we have to find out whether the legal right of the petitioner has been violated. Suffice it to say that the legal right of a particular petitioner shall be violated if he or she has the right conferred on him or her by a statute. So far as engagement as of MR dealer or distributor is concerned, an applicant has the right to be considered only provided he or she is otherwise qualified and eligible. If, however, he or she is not otherwise qualified, he or she has no right to be considered even. This being the position under the public distribution system a person has a right culminating into a legal injury only when he or she is otherwise eligible but not considered favorably. If he or she is not otherwise eligible for consideration, and if he or she has not made out a case to show his or her eligibility by proper pleading and supporting evidence, he or she shall have no right to contest the selection of another for MR dealership or distributor. Any imaginary or psychological trauma by such petitioner cannot be considered for grant of relief under the said jurisdiction. In the present case, at the cost of repetition, we would say that in the writ petition, the petitioner has not challenged the rejection of her application by the state respondent. As she has not challenged the rejection of her application, it was not the duty of the state to convey to her as to on what ground her
No, that is
application
not the case here. He has also
the
challenged
writ
this.
petition he has not challenged. By way of a supplementary, a single line has been there that the order of the principal secretary is bad. I can show the prayer. This prayer is not there, that the challenge is not there. Nowadays, after coming into force of the Right to Information Act, when so and so, kindly skips over that part. Thereafter, the writ petition respondent number 1 filed the present writ petition. Therefore, the writ petitioner respondent number 1 cannot feign ignorance as to on what consideration it was found ineligible. It was therefore the duty of the writ petitioner respondent number 1 to plead and prove that it is otherwise eligible, and overlooking its eligibility favor has been granted to the appellant in the violation of Article 14 or in derogation of the duty enjoined to the respondent. Coming to the second most important question raised by Mr. So-and-so learned counsel for the respondent is concerning non-communication on the ground of rejection or cancellation. Concerning the non-communication on the ground of rejection or cancellation of the application to the petitioner. This is not such a lapse to give any legal right to the writ petitioner respondent number 1 to challenge selection of the present appellant, especially in view of our discussion supra. If the writ petitioner respondent number 1 would have been able to plead and prove that it was also otherwise eligible for consideration, this ground would have different effect in the entire issue. So he has to be first eligible. Honorable single judge, while dealing with the writ petition, has far exceeded the scope of judicial review. So and so, that is discussion on the kindly 13. We do not disagree with the proposition, as the authorities cannot perform any duty in derogation of the terms of the advertisement and the eligibility criteria. In the instant case, when the authority is satisfied about eligibility criteria, the negligible flaw in the decision-making process cannot be made a ground to unsettled and already settled position. Similarly, in view of the fact that the entire process has been done in a hot haste and the approval has been accorded on a Sunday, which is a public holiday, the two views are possible. One, as the engagement of the caption MR dealership was delayed by legal process for about 5 years, the appropriate authority might have thought it proper to do the same as expeditiously as possible, or the appropriate authority complete the process in hot haste with a malafide intent. If two views are possible, but in our case, two views are not possible. Only one view is possible, that our process, decision-making process was not so a disarray that it has to be set aside. The Malad kindly takes 22, volume 6, SCC 127. It is also referred to in the division bench. 2022, volume 6, SCC 127. Para 15.
NG projects referred to
15 May I place paragraph 15
Yes.
In Uflex versus State of Tamil Nadu, this court stated that the enlarged role of the government in economic activity and its corresponding ability to give economic largesse was the bedrock of creating what is commonly called the tender jurisdiction. The objective was to have greater transparency and consequent right of an aggrieved party to invoke the jurisdiction of the High Court under 226 of the Constitution of India, beyond the issue of strict enforcement of contractual right under civil jurisdiction. However, the ground reality today is that almost no tender remains unchallenged. Unsuccessful parties or parties not even participating in tender seek to invoke the jurisdiction of the High Court under 226 of the Constitution. The court held as under. The judicial review of such contractual matters has its own limitations. It is in this context of judicial review of administrative actions that this court has opined that it is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. The purpose is to check whether the choice of the decision is made lawfully and not to check whether the choice of the decision is sound. In evaluating tenders and awarding contracts, the parties are to be governed by the principles of commercial prudence. To that extent, the principles of equity and natural justice has to stay at a distance. We cannot lose sight of the fact that a tender or a contractor with a grievance can always seek damages in civil court and attempts by so and so. But that is not quite important for our purpose.
Probably it is now settled, Mr. Bandyopadhyay, that if the challenge is to the terms of the tender itself, the very process of then if you participate, you are gone. You cannot participate and you have to challenge. But if it's regarding implementation of the terms of the tender or unfairness in the process of, then
you can
you cannot otherwise come.
Right. You cannot otherwise come.
So here he participated, he's not challenging the grounds of tender, but he's saying that no, the process in which you implemented it was wrong.
Yes, but here my answer to that is that he cannot come and say that my decision was wrong. He can come and say that my decision making process was wrong.
And also your another argument which is supplemented to this, which is he was shut out at the eligibility stage. So not that he had a license, it was cancelled or some other stage subsequent.
If it was a fresh matter, two applications like it was before in the erstwhile round, the issue of locus would have been different. Today, kindly perceive this. His locus is not also at a pedestal of an applicant seeking a fair adjudication of his application. His locus stems from an order passed in an earlier writ petition only to the consideration of his representation after giving a hearing. From that, kindly sees the effect of these orders upon the state authorities. A simple order of consideration or representation upon hearing has snowballed into another round of litigation, then another round of litigation, then appeal, then again setback, remand. It is a locus brought out of a consideration order. Today, I will go to the extent of saying his locus is not even up to the mark of an applicant seeking fair review. His locus is only to the extent that upon that order being passed, whether I heard him and I passed an order or not. If I have heard him and passed an order, irrespective of the fact whether a re-inquiry was directed or not directed, I have complied with the order. His part of grievance has ended. He cannot make a mountain out of a mole today, saying that this is not there, that is not there, hearing not given, inquiry report not given, and taking it to the pedestal of a disciplinary proceeding and preponderance of probability. And I'll have to prove my case to that effect that why my decision was right, why your cancellation was wrong. I am not required to do that. You do not have that locus at all. The next judgment is on the aspect of the copy.
If it's on the same point, don't.
It is the earlier two judgments was the right as far as vis-a-vis an unsuccessful candidate is concerned.
Yes.
This is on the judicial review of a selection process connected with the MR dealership. This is MAT 2084 of 2024. Kindly takes paragraph 7 to 13. Internal page 4.
Yes.
Having regard to the entire facts and circumstances of the case, this court is of the view that there is some evidence of the eligibility of the appellant. Such evidence is clearly borne out of from the records. It is not for a writ court to weigh the evidence and to decide how much more marks the private respondent ought to have been given as opposed to the appellant. It is equally not for this court to see whether the final deed of conveyance was obtained by the appellant after the last date of application. This court finds that these are subjective issues within the realm of the state, since it is quite possible that an agreement of sale along with possession can in some cases be also accepted. The learned single judge has erred in entering into the disputed questions of fact of the selection process. It is true that the state distribution of largesse is required to be transparent, fair, and devoid of arbitrariness and capriciousness on the lines of the decisions of the Supreme Court from Ramana Dayaram Shetty to so-and-so natural resources for particular so-and-so. Then para 10. An important principle of law on the subject of the state distribution largesse and particularly the government tender is the concept of play in the joints, has emerged from the decision of Tata Cellular and has been reiterated in the case of Ronak International. The dicta laid down in the aforesaid two decisions is that while it is possible that the private respondent writ petitioner may have fulfilled all or every criteria to letter and spirit, and the appellant may have missed out on fulfillment of some criteria, this court should refrain from sitting in appeal over the decision of the state. The reason, therefore, is that the state is the best place to determine which contender is most suitable for being awarded distributorship. A writ court does not sit in appeal over this administrative decision when more than one view is possible. The court cannot and does not substitute its own view with that taken by the administrative authority. As already stated herein above, the appellant prima facie appears to have fulfilled eligibility. In such a situation, it would be graciously inappropriate for a writ court to enter roving inquiry to exercise the selection process with a microscope, much less sitting an appeal over an administrative authority's decision. Now, this order traveled to the Supreme Court and it has been upheld subsequently. On 21st of March 2025, where the special leave petition was dismissed. Now, my lord, only 5 lines I'll place from the next decision. That whether, on the point that whether they are entitled to say without a stay of the process that I could not have granted the license. But if that prayer having been there, that prohibition prayer was there in their earlier writ petition, that having not been determined by the honorable judge, my lord, it is understood that that prayer was rejected at that stage. So this is 2001, volume 1 SCC, page 73.
2001.
Volume 1 SCC, page 73, para 8. But kindly turns to the last page of the printout, which is part of para 8.
Yes.
Need not go through entire para 8. Kindly comes just above placetum B. It cannot. Just above placetum B. It cannot be spelled out.
Yes.
It cannot be spelled out from the award in the present case that such a right or benefit had accrued to the workman as the specific question of the relief granted is confined only to the reinstatement without stating anything more as to the back wages. Hence, that the relief must be deemed to have been denied for what is claimed but not granted necessarily is denied in judicial or quasi-judicial proceeding. So, if that prayer was there but not granted, it has to be deemed to be denied. In fact, the Honorable Single Judge clarified that all later decisions can be implemented by the state authority. Which includes the decision of appointment. Now, my lord, with regard to the law applicable as on the date of vacancy, because the form change in the meantime. Yes. The 2015 volume 8 SCC 484. Paragraph 8, my lord, kindly skips over the first 3 lines and take the 4th line between placetum E and S.
Yes.
In our considered view, the issue noticed at the outset must be decided on the basis of settled law noticed by the learned single judge that the recruitment process must be completed as per terms and conditions of the advertisement and as per the rules existing when the recruitment process began. So, my lord, the question is, when did the recruitment process begin? But for that, kindly takes 2025 volume 2 SCC page 1 settled law. Paragraph 22.
2025.
Volume 2 Supreme Court cases page 1. 22.
Yes, 22.
The process of recruitment begins with the issuance of advertisement and ends with the filling up of the notified list.
At the time of the advertisement,
At the time of the advertisement.
first.
So the form that is page 1.48 of this book, that is, and serial number 32 will apply, and not the subsequent amended form which has perhaps been handed over by Mr. Agarwal.
That you please hand over a photocopy
I'll
of that,
with
that
my
relevant
note.
rule only. And just write on top what is the rule about. Probably the page contains a superscript on that.
Damalad, before Malad, I raise the next judgment. Malad, if I may point out that out of the few decisions which has been cited by my learned senior, the 2006
Yes, 4. Volume.
For HCC 713, he has placed that inquiry officer is not permitted to use any further material. It is on that point.
Yes.
It is not supplied. Then 1993 volume 1 HCC page 13.
These are mostly probably on departmental proceedings.
Yes, order is based on undisclosed material. All service number are checked up.
Sorry, yes.
Then Malad, 1994 volume 5 SCC 118. Order passed on the basis of undisclosed material. All are there. Malad. These points. But for all these, the first of the broad point is that the standards of dismissal proceeding will not apply. This I have already said. But Malad, for all these points to apply, the petitioner has to first plead and prove a case of prejudice. Neither in the writ, nor in the stay application, nor in the affidavit in reply filed in the pursuant to the stay application before your lordship, nowhere this case of prejudice has been set up by the writ petitioner that because of non-supply of these documents, they have been prejudiced. Nowhere.
Yes.
Hearing was given by this. After hearing, উল্টো কথা বলা আছে।
On that point, kindly takes 2008 volume 9 SCC, page 31. 2008 volume 9 SCC, page 31. Twenty and
Para?
Para 20 and 21.
Yes.
Holding that it was incumbent on the delinquent employee to show prejudice, the majority held that non-supply of report of the inquiry officer to delinquent employee would not by itself make the order of punishment null and void or non-exist. Then B. Karunakar is not quoted thereafter 21. From the ratio laid down in B. Karunakar, it is explicitly clear that the doctrine of natural justice requires supply of a copy of the inquiry officer's report to the delinquent if such inquiry officer is other than the disciplinary authority. It is also clear that non-supply of report to the inquiry officer is in breach of natural justice. But it is equally clear that failure to supply a report of the inquiry officer to the delinquent employee would not ipso facto result in the proceeding being declared null and void, and the order of punishment honest and ineffective. It is for the delinquent employee to plead and prove that the non-supply of such report had caused prejudice and resulted in miscarriage of justice. It is if he is unable to satisfy the court on that point, the order of punishment cannot automatically be set aside. Malad, if your lordship gives me 5 minutes, Malad, I'll just 2 more decisions, Malad.
Heard in part. The matter will be listed for further hearing on August 25, 2025.
Your lordship on the last occasion asked me to give an order.
The gazette notification where on what point what marks are there.
that we have today.
So you file it along with your written notes of arguments.
But otherwise they won't get the opportunity to deal with it.
My lord,
Acha, well, hand it over.
I'll bring it
My
up.
lord. Item number 34 of today's daily list, I'm praying for not this week, lordship.
No, automatically it becomes not this week. If you don't take up, tomorrow we sit singly.
No, my lord, we are not prepared actually.
Tomorrow we sit singly. This bench will not be.
But under,
Grateful, your
under
lordship.
extreme urgency, may I be permitted to mention, especially,
এই বইগুলো ফেরত দিয়ে দাও দীপঙ্কর।
may I be
Yes.
permitted to mention a specially assigned, my lord, appeal from an interlocutory order passed in the originating
Give the
summons
number, it
suit.
will be listed.
My lord, I was only humbly submitting this. I know my lord usually takes up original side appeals on Wednesday.
I'm opposing the mentioning.
My lord, there is extreme urgency in the matter, my lord. Our trust and two companies, all assets have been frozen, my lord. The matter was listed before the regular bench, my lord. Was pleased to release it yesterday. It was assigned before my lord.
No orders have come up in the server yet.
It will create
Order
conflict.
The date, returnable date before the interlocutory court is tomorrow itself, my lord. If my lord takes,
Side that you have mentioned, submit it to the page, wherever. it is.
may I give the on number, my lord. The
It's number,
assignment
এটা-
order
এটা-
also, the assignment order is also there, my lord.
আছে এখানে?
7 number matter টা, assignment order টা।
বুধবার দিয়ে দিও। ও দিয়ে দিও list, নিয়ে নাও ওটা। Mentioning script টা রেখে দাও। Automatically it would be given in Wednesday. Whenever assigned matters come to us, we put it on the list.
Very well, my lord. I'm mentioning so that it does not come as to be mentioned and we can like move the stay
আপনি mention
application.
it.
Usually, my lord, when it
No.
comes for the first time, it comes.
We are sitting in that bench now only for the assigned matters.
Oh, very well,
The
my lord.
original matters, part heart matters, content matters are already over. We sat for that. Now, once we are sitting, those matters are, several matters are being assigned to us.
Will it be possible?
And two families are keeping us engaged in that original side matters. So we don't know
I
whether we can
understand.
reach your matter. Those two families, if you can overcome those families, then we can reach your matter.
Difficulty, my lord, one trust and two companies.
Come in the list, we will consider.
Without any application being filed, my lord, ex parte ad interim
We
order.
cannot jump the queue. There are so many matters already.
I'm grateful to my lord for considering.
Grateful.